has appointed the offices of rulers and parliament for the welfare of society and just government of men. We beseech thee to behold with thy abundant favor us thy servants, whom thou hast been pleased to call to the performance of important trusts in this land. Let thy blessing descend upon us here in this house assembled. Grant us that we may treat and consider all matters that shall come under our deliberation in so just and faithful a manner to promote thy honor and glory, to advance the peace, prosperity, and welfare of this country and of those whose interests thou hast committed to our church. Amen.
Correction and approval of records of votes and proceedings of the National Assembly sitting of Thursday, 7th March 2024.
Honorable members, the record of votes and proceedings of the National Assembly sitting of Thursday, 7th March 2024 is before us for correction and approval. Can any honorable member please move that the said record of votes and proceedings be considered and approved? Honorable member for Opanyumi.
Thank you very much, Honorable Speaker, for giving me the opportunity. Honorable Speaker, I rise to move that the record of votes and proceedings of the National Assembly sittings of Thursday, 7th March 2024 be considered for correction and approval. Thank you.
Thank you very much, Honorable Member for Opanyomi. Any seconder honorable members? Honorable Member for Pony Bondali.
Thank you, Honorable Speaker. I rise to second the motion.
Thank you very much, Honorable Member for Pony Bondali. Honorable members, it has been moved and seconded that the record of votes and proceedings of the National Assembly sitting of Thursday, 7th March 2024 be considered and approved. Honorable members, we all have copies of the shared record of votes and proceedings, and as usual, we look through it page by page where members may comment. We begin with page 1. Honorable members, page 1, please. Any comments? No comments on page 1? We move to page 2. Pardon? Woolly East?
Yes, sorry, I was busy doing something. Laying of papers. That is one thing that we need to correct there. It should be papers.
Number 1, honorable members. Number 3 on page 1, laying of paper. Papered. It should be papers. The
Yeah.
D should be S.
Exactly. And then on the 3, the first line, where you have regional integration, it should go along with unemployment. I think that's the, and wherever it is. Because it's in several places. Regional integration and employment should be part of it, right? And if you go to 3, you just put comma after lands. Then you go to ombudsman.
Number 3, Roman 2, report of the Select Committee on Trade, Regional Integration and Employment. Isn't it? Then you said 3.
Line, there should be a comma after lands. Yeah.
That is report of the Select Committee on Regional Government and Lands, comma, Ombudsman and the IEC of the National Assembly. Any more honorable members? We now move to page 2, honorable members. Page 3, honorable members. Honorable member for Sani Mentoring.
Thank you very much, Honorable Speaker. On page 3, for number 1, correction and approval of record of votes and proceedings of the National Assembly sitting of Wednesday. So there is a paragraph underneath which says Honorable Aliu Balde, member for Jara West, moved the motion and it was seconded. I suggest we delete it and Honorable Aliu Balde, member of Jara West, moved the motion and was seconded by Honorable Padem Bosani. Thank you.
Comments, honorable members? I think she is advocating for the removal of it. Am I right? Move the motion. It refers to the motion, isn't it? And the motion was seconded. Any more on page 3, honorable members? We move to page 4. Honorable member for Woolly East.
Yes, thank you. On the suspension, the second line, the paragraph on the suspension and resumption, where you have prayers and lunch break, there should be a full stop at break and remove the minutes. I don't see the.
Yeah, on the suspension and resumption of the assembly, order 13. Which one are you making reference to? Which line? Second line.
At the, where you have lunch break, full stop. And then the minutes, you remove the minutes from there. You've seen it?
Let's read it. At 50 minutes after 2 o'clock in the afternoon, the Honorable Speaker suspended the Assembly for prayers and lunch break.
Full stop.
And what about the minutes?
You
the
remove
minutes
that
should be
one.
removed.
Remove.
The minutes should be removed. Deleted, yes. Continue, Honorable. Then the Assembly resumed at 20 minutes after 4 o'clock in the afternoon. Is that okay? Yeah. That's is removal of the minutes. And? Yeah, full stop. Honorable members, we following. after suspension and resumption of the assembly, the first line should end at break, lunch break, full stop. The minutes should be removed. Now we move to page 5. Honorable Member for Sani Mentre.
Thank you very much, Honorable Speaker. On page 5, where you have Roman number 2, which says report of the Select Committee on Trade Regional Integration of the National Assembly. I suggest the National Assembly wouldn't be necessary here because this is a report of a select committee, which clarifies already that it is a report of a National Assembly, a select committee at the National Assembly. So I don't think it would be necessary for National Assembly to be here. That's my opinion. Thank you.
Yes?
Yes,
Honorable
I think it's necessary because that has been a trend as far as it concerns the Select Committee of the National Assembly. Yes, for consistency.
Yeah, I also thought so because the previous ones, the same thing has been said. And again, I thought you were going to say regional integration and employment.
He said wherever it is.
Pardon?
When I was suggesting, I said wherever it is because I saw it in.
Okay. Any more on page 5? I only hope the same thing would apply as corrected on page 3. The last paragraph on page 5. The removal of it. Honorable members, we now move to page 6. Honorable members, we move to page 7. Honorable member for Sani Mentre.
Honorable Speaker, I'll apologize for taking you back to page 6 on Roman figure 3.
Now, Honorable, just let's complete page 7 first.
Okay.
Anything on page 7? No more on page 7. Okay. Then we now move to page 6. Honorable member for Sani Mentre.
Thank you very much, Honorable Speaker. On Roman number 3, which reads report of the Select Committee on Regional Government and Lands, there should be comma between lands and ombudsman because these are two different institutions. Sorry? Okay, thank you.
Honorable members, it has been moved and seconded that the record of votes and proceedings of the National Assembly sitting of Thursday, 7th March 2024 be approved with amendments. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Clerk, may we proceed?
Bills. Order 72, consideration stage of the Criminal Offences Bill 2020 by the Honorable Attorney General and Minister for Justice.
Honorable members, you will recall that in the previous session, the Standing Committee on Human Rights and Constitutional Matters reported on the bill committed to it. That's the Criminal Offences Bill 2020. The report of the committee was adopted. Accordingly, the consideration stage for the said bill was scheduled for today. During the consideration stage, members shall have the opportunity to give detailed consideration and scrutiny to every clause and schedule in the bill. This stage also provides the first opportunity for amendments to the bill to be debated and voted on. I will now therefore resolve the Assembly into the Committee of the Whole Assembly to give consideration to the bill. Into the Committee of the Whole Assembly.
They are the committee members.
Yes. Honorable Member for Lower Florida. How are we? What is it? Honorable members, we will resume the committee of the whole house, but it seems, I do remember that we are in Ramadan. Some people are beginning to show signs of Ramadan. It's too early. I am surprised, but I usually, it's more the people from the, I don't mention them. So, honorable members,
He's warning to everyone.
the Assembly will now go into the Committee of the Whole Assembly to consider the Criminal Offences Bill 2020, clause by clause. We will also be guided by the committee's report on the bill and, of course, Order 72 of the standing orders during the consideration stage. Honorable members, you have the report of the committee on the Criminal Offences Bill. That will guide us. So as we, honorable members will make the necessary observations as we move. Who is the chair of the? Yes. What happened? What happened? I saw that, Madi, you dodged from your... I was going to think that Swaibu was going to meet you. Madi, don't defend Swaibu. Okay. As we said, we look at it page by page. Sorry, clause by clause. Beginning, of course, with clause. No, clause by clause is, yeah, if we are fast, we can be fast. Yes, it's more specific in this case. Otherwise, you say part by part, people will, you can miss a lot of things. Yes, clause by clause, huh? If we want to be fast, we can be fast. If we have done our job on the bill and that we have made our observations, we will go fast.
Clause 1, subtitle.
It is proposed that clause 1, subtitle, stand part of the bill. Those in favor? Pardon? You have observation?
Yes.
Yeah, okay.
It's with amendment. And the committee proposed that the title of the bill reads Criminal Offences Bill 2024 now.
Yes, 2020.
2024.
Honorable members, you've seen it as the Criminal Offences Act 2024. Thank you. Honorable members, it is proposed that clause 1 stands part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 2, saving of certain laws.
It is proposed that clause 2, saving of certain laws, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 3, interpretation.
It is proposed that clause 3, interpretation, stands part of the bill. Yes, yes.
On the interpretation, we have the definition of disciplined forces. the committee proposed that the following form part of the interpretation section of the bill. That is disciplined forces. We want to include that. Yes. In paragraph 6, we define as armed and security forces. Yes. That was our,
Forces
yes, to be
included.
yeah, to
okay.
include.
Okay.
Where is it? Yes. Where is the discipline force?
Invite comments from the AGs. Armed and the security forces, isn't it?
Yes. That was our agreement, yes.
That was the agreement.
Yes.
You know, Chair,
Yes, please.
in the bill, disciplined forces means the armed forces or the National Youth Service. So now we are recommending that, it include armed and security forces. Instead of, yes, it's defined as, yeah.
Is the inclusion of security and security.
Definition, we are dealing with definition.
Yes, it means armed forces, instead of armed forces, armed and security forces. Am I right? And then it continues. Oh, you want, yeah, so that be there and the National Youth Service be deleted. Are you following, honorable members? Yes. Yes.
But, Honorable Speaker, we are not clear here. He said in the bill, you have armed forces and national youth services. So now if you should remove National Youth Service and put only security there, I hope that will not affect the content.
Means armed and security forces.
Yeah, but you are now removing National Youth Service.
That is the proposal.
Yeah, but okay, I'm against the proposal.
Yeah, exactly. Why? Why? Yeah, give reasons.
You are not following me. Okay, once again, I said, according to him, the bill entails armed forces and National Youth Service. Now, if you should take out the youth service there and replace with security, I'm saying to me, that's going to affect the content of the bill. Unless otherwise, what he means by the security forces, will that take care of the National Youth Service? And National Youth Service, they are not security.
Yes, I think if you look at the committee's recommendation, they are only recommending for the deletion of discipline forces as defined, to be defined as armed and security forces, then, comma, or National Youth Service should be there.
He's saying that what they are saying
But it's not
is
deletion of youth service. Is not,
disciplined forces
yes.
to now be interpreted as armed and security forces only.
Okay.
The National Youth Service should be deleted. That's what the honorable member for Central Badibu tries to, yeah, he's saying that completely excludes the original intent. Why? Let's ask ourselves, why was the National Youth Service added? Yes, Honorable.
The National Youth Service is not a disciplined force. It's a youth service. We are talking about disciplined forces. That means the army, and other security and the police. They are considered disciplined. But youth service is not a disciplined institution. It's not a disciplined force.
It may look like why they are defining this is the wearing of the uniform. And the National Youth Service, they wear uniform. If you exclude them here, it means they will not be qualified to wear uniform.
During training, yeah.
Yes, they have their own fatigue. They have their own. And I think that's my I think the honorable members can come in. Yes?
Yeah, I don't think that should define, that should qualify them to be called discipline forces. Having their uniform, to me, like you have the scouts. No, I'm coming. The scouts, like the Boy Scout, but it doesn't qualify them to be discipline forces. So, in a nutshell, I don't think removing the youth service would create any harm. It's in line. They are not qualified as discipline forces. Because if you look at it, if we are trying to advance justification that they wear uniform, Scout does wear uniform, but they're not discipline forces.
No,
Chair.
my problem actually is, why was it in the first place included? Is what we should ask ourselves. If you know the intent of its inclusion, then we'll be able to determine whether it's right for us to exclude it or include it. Yes, Honorable.
They are not a discipline force.
You are looking at this.
Yes, thank you very much, Honorable. Honorable Chair, I think I will align. He called me. I will align myself with the honorable member for Central Badibu. I will suggest we amend as the committee is recommending, but let us not leave out the National Youth Service. Like you said, the new interpretation will read as discipline forces. It will mean armed and security forces or the National Youth Service, so that we can settle this matter once and for all. Yes? The minister can help us, but if not, as you are proposing, I'm also against that proposal.
Let the honorable minister please clear the air for us. Yeah, yes, Banjul South.
Thank you. Mr. Speaker, I think this was thoroughly debated during the presentation of the report, and it was clearly agreed here that the youth service are not forces. They are not forces. They are just service.
If you look at the meaning of a discipline force, they said the discipline force means the police force, the correctional institutions, service, or any service or force prescribed by the regulation or any other act to be a discipline force. So you cannot say youth service is not a discipline force.
Where are you reading?
I'm reading from
Google. Can we have the honorable minister?
Honorable Speaker, they are not a force. I think they're giving a kind of a discipline kind of training because it's a kind of formation to prepare young people to inculcate some kind of discipline in them. So, but that doesn't make them a force. So they are not a force, and we have discipline force defined in the Constitution of the Gambia under Section 230. It's a discipline force means the police force, the prison service, and the armed forces. So national service is not a force.
Well, my problem is, Honorable, why the inclusion?
Yes, so I had you ask that question.
Let them tell us it's a mistake. We are asking the drafters to give us the intent why they did it. They can tell you it's a mistake. They can tell you because of A, B, and C.
In the end, we drafted it, but it's parliamentary intent that should guide us.
Yes.
Government is a continuum, so I don't want to give any excuse, but I found this bill introduced. All right,
Anyway.
so I'm continuing.
Okay.
So I don't know the intention behind it.
All right.
Yes.
So, honorable members, it looks like from the arguments of Banjul South, this has been thoroughly debated, and it was agreed that it should be removed, and then it should be amended as proposed.
It was also based on the definition from the Constitution as well.
Yeah, but that was the agreement. There are no new inputs. Yes?
Please, because I think there is a clause. Can I come? I mean, there is a clause that deals with the youth service, isn't it? In the bill. Or there is no clause that deals with it? Or a part? If there is a clause or a part, that talks about it, why not we also separately define that? The youth service scheme that they're talking about. Or there is no need to define it? Okay.
No, wait. When we meet there, we can. Chair, I'm saying, since we are not yet there, when we get to that stage, you can come up with this suggestion instead of derailing us at this.
All right, we look through it. Wherever we see it and we feel that there is necessity, you can make suggestions. Honorable Suleiman, Honorable Central Body, I told you, make reference to me. No, he's not attacking you. You are attacking. Because you are the one looking back and talking to him. He is looking at me. So, honorable members, what do? We discipline forces means the armed and security forces, full stop.
Honorable Speaker, I think we adopt the constitutional definition. If there was no constitutional definition, we will be at liberty. But if there is a constitutional definition, we should be limited to the constitutional definition. And the Constitution mentions 3 only.
That is what?
It says the police force, prison service, and armed forces. That's how the Constitution defines discipline force.
Which one is the armed one now?
Well, the armed forces will be the army, and within the army, there are different units. You have Navy, National Guard, but as long as they are armed forces, that's Gambia Armed Forces, GAF. Police and the prisons are the ones that are listed as discipline force. But in our real life, we tend to perceive more than that. Because the immigrations is a discipline force in the way we deal with them. The customs, border enforcement is a discipline force. But I'm saying the Constitution have defined it for us, going beyond the constitutional definition.
We are fine then?
No, we are not. We are not. We are not still fine.
Yeah, yes, Honorable.
We are safe to go.
Yes, I think in the bill of National Youth Service Scheme, when you look at their training and what they work onto, discipline is also inculcated into their affairs. So I believe we leave it as it is, so as for it to be included, part of it.
What is clear now is
yes,
we cannot go contrary. The Constitution is the supreme law. Whatever amendments you make now, if it conflicts with the Constitution to that extent, it's null and void. So what the Honorable Minister is telling us, that the Constitution has defined armed disciplined forces. And that definition is what we cannot go beyond. We cannot define it any other better. That's why we are close. Yes, Honorable. So, yes. Honorable,
yes.
No, Honorable for Woolly East.
Yes.
So we now have means the armed and security forces, full stop. All right, any more?
The minister responsible of this bill, we proposing that is the minister for the responsible for the administration of justice. That's the Attorney General and Minister of Justice, isn't it?
Minister means here the minister responsible for the administration of this act.
Yes, justice. Minister is not defined in the Interpretation Act. So we want it to be included, so that there will be no confusion as to which minister is responsible for this act.
You mean the definition should be corrected? Because it's there already.
administration of this act is not specific to which minister. Whoever is assigned is the one who will do it. You are now saying, let's be specific, call the minister. Am I right?
Instead of saying is the administration of this act.
This is what I'm saying.
You want to be specific to say is the Minister of Justice.
Yes.
Yes.
You know, administration of this act can be the Minister of Justice, can be the Minister of Interior, can be what? You know, it means you are assigned, you do it. You are now saying we be specific. Yes, yes, Honorable Member.
I was looking at the spirit here because this bill would certainly belong to a ministry. And there is sense in what they crafted here, that the ministry responsible for the administration of this act should be the minister here. So I don't see wrong for someone who is now administering this thing, that minister should be responsible. Yeah.
Yeah.
Rather than, you know, try to specific. So at any given time, whosoever is now responsible for the administration of this act, you should be the minister. No, it says the minister responsible for the administration of this act.
Just raise your tag and we call
the minister. Speaker, one more time. Minister means here the minister responsible for the administration of this act.
Yes.
Yes.
No, what you are saying is this is up. It's okay. Any minister who is assigned for this administration is the one it refers to as the minister. What they are saying is, let's identify a specific ministry to administer. That's what they are saying. Now, these are the two areas. Yes, Honorable Banjul South.
Yes, Mr. Chair, I think the reason we specifically said the Minister for Administration of Justice was because that minister is also the legal advisor of the government. That's why we wanted to be specific. Otherwise, if we leave it to this act can include, like somebody mentioned, interior, but we wanted it to be specific, and that's why the committee recommended this.
Well, like I said earlier on, technically, anybody who is responsible for this thing must understand the portfolio. So, living like this is apt. Minister responsible for this act should be the minister here. He cannot be minister for health to be responsible for this act. Technically, he cannot. There is no given time.
So how about interior?
There is no, even interior cannot be.
One that specific. But do you know that the president can assign any specific duty to any minister? As even by the provisions of this very act. It's the responsibility of the president to assign you. National Assembly member matters will switch from one ministry to the other. It's the president who makes that determination.
An example.
It's not a position per se. That's why I'm sure the drafters probably put in this act.
Example, the current Minister for Public Administration is now overseeing the Minister of Lands. So issue of his lands now, under the present appointment, he should be responsible now to administer, please, order, please. At any given time, when the president now gives that power to any minister to administer this act, he used to be able to do it. Now I'm tying it to Attorney General.
And make your summary. Yes, Honorable Member for Sami.
Thank you very much. Thank you very much, Honorable Chair. Honorable Chair, I think the committee's suggestion is in line. by saying that any minister that's going to be responsible of this act should be somebody who knows this thing. So therefore, I think minister responsible for justice is in line. Yes.
Now, honorable member, let's get some few things, otherwise we will spend the whole day on it. Yes, I'm coming to you. One, nobody is arguing about that. What is arguing, the prerogative to assign these things to ministers is the prerogative of the presidency. All right. What we are now saying, somebody can be somewhere, he is legally minded, he's an expert in law and all these things, while some other things, he can be assigned. That's the agreement.
But he or she will not perform well.
He cannot, he or she cannot.
He will not perform well.
What do you mean cannot perform well?
Because if you put somebody there in that position and he or she did not know anything in that.
No, you are not paying attention. For instance, now, interior minister can be an expert in law. Or whatever. He will have all the qualifications. He can be assigned to oversee it. What we are saying is, we must be careful not to also take away some powers vested in the presidency. We have to mind those things. I think we need some legal and technical. Wait, you will come after them. Yes. Woolly is. I think let's have Woolly will clear Joshua and all your doubt.
Yeah, the Attorney General is responsible for the Ministry of Justice, and in the Constitution, everywhere you go, the Attorney General and Minister of Justice must give consent before certain proceedings are taking place. It's all over the place. So if you put, if you leave it blank, and then they go and give this responsibility to a Minister of Health, as somebody is saying, or a Minister of Interior, and it's the Attorney General that should give consent before proceedings take place, in certain cases. How is that going to work? That's why we are saying, let's be specific here. Since it is meant for the Minister of Justice, we put Minister of Justice, so that there is no ambiguity in that.
I'm convinced.
Yes, that's
I'm convinced. What he said. Yes.
Assigned to certain provisions that makes it mandatory for it to be to be taken care of by the Attorney General. And I don't think the presidency does not have powers to also bend that portion of it. I think we tend to agree that we be specific. Are we all online? We are able to agree until we are able to get to a solution. So we now put what? Minister means the minister. No, the Minister for Justice, or for the administration of justice. So minister means the minister responsible for the administration of justice. We are fine. Okay, can we continue, Honorable Woolly East?
One is the definition of civil office. I don't think that was captured, but we want it to be included. And let it be in line with what is in the Constitution. That's what we recommended.
Civil office?
Yes.
CIVIL?
Yes.
Yeah, that will come a little, these things are in alphabetical order. So we will, what do you want it to be?
It's not captured in the definition section, yes, interpretation section. So we want it to be included.
then we have to, you people should have had the time to craft one for us.
No, it's in the,
Because we must have one now.
It's
Otherwise,
already-
we can't continue.
it's already in the constitution, so we're saying what is in the constitution should.
Now you read that for us. What is in the constitution is what you should tell us.
You need.
Huh? Let's hear him. What is the word self? Civil office.
No,
civil offense or office.
Chair, it's an assignment to the ministry to put that. The drafters to put that.
That's all.
Who are talking to the justice minister? He's talking to him. It must come to us for approval and then we agree first. That's why it should be done before now. We now have to go ahead and do it. But if you look at the next page, page 15. 15. Yes, but look at page 15. Have you seen it? Look at A, civil office. Page 15. You know, it starts with persons employed in the public service, means any person holding any of the following offices or performing the duties thereof, whether as a deputy or otherwise. Namely, a civil office, including the office of the president, the power of appointing a person, any office to which it's not defined. It's not defined. So what is the definition? What is the proposed definition?
Chair, our report, we agreed and recommend that these things should be defined, and that is not for us. At the retreat, it is for the ministry to come up with definitions here. These 3 and 4 is for them to come up with something at the retreat.
Yes.
Yes, but that's what we said. You look. We said civil office should be properly defined and be in line with the Constitution. Then you have the fourth one also, sexual act. Consider the definition to be in line with the definition of the term in the Sexual Offences Act. It's for the ministry to come up with something. That's our recommendation.
The problem is, was the ministry aware of that? And 2, was the civil office defined in the Constitution? In the Constitution, I'm being told that it's
Don't say it should be.
It's not defined there.
He said it should be now.
I am told, let's not waste time. I am told that it's not there. It's not defined.
It says in line with the Constitution. It doesn't say as defined.
In
It says
line,
as in line.
that is so vague, in line. Why don't you come out with proposals? Yes.
Because it's public office. So this time, civil office is not there. So only it's a new term that they use here. So what the correct term is public office. Instead, they use in the Constitution there is public office.
Yes.
Honorable Chair. Yes, thank you very much. I think the committee and the ministry rather, should help us make progress. They did this together. Was there any consensus? Where are the proposals so that we can adopt and move? Please.
Is civil office different from public office? Huh? I want people to comment. You can comment.
No, I think we are public officers, but we are not civil servants. That's what.
Civil servants. I'm in civil office. Public office.
There's no time like civil office.
Because I'm beginning to see civil office in this bill. I'm not used to the word. Are we used to the word civil office?
No.
No, it's just being used. So does it mean civil office? Does it mean public office? Attorney General, can you people help us? Yes? Honorable Member for Woolly.
Yes, please. Honorable Chair, you know, in page 15, what is being defined there is person employed in the public service. And it has A, B, C. But when it is saying A, B, C, it mentions a civil office, which includes the office of the president, the power of appointment. Then it says B, any office to which a person is appointed or nominated. So all that definition is, you know, the definition of a person appointed in the public service. So since they are mentioning civil service, a civil office, this is why we want the drafters to help us to define that so that we will properly capture it to be different from the public service. If
Chair.
they are indeed different.
Chair.
That is our objective.
Chair, let me give the definition. Speaker, Chair, let me give the definition. My own definition is any office that exercises authority over civilian should be seen as civil office. The need for us to interpret this is born out of the fact that it is used in A and other places. Why don't we say a civil office, instead of a civil office, a public office?
Thank you, Honorable Speaker. The word civil office is a novelty in our laws, ranging from the Constitution right down to other legislation. We are not used to using civil office. We only have public service, public office, or civil service. I don't know, so using civil office is clearly causing misunderstanding for us at the moment. So, but I'm looking at the term that they are even seeking to define. It's a person employed in the public service. And the public service is already defined under Section 166 of the Constitution. So we can simply say, as defined under the Section 166 of the Constitution, we adapt that, because under 166, we must understand there is a broad definition, 166 in the Constitution. Well, 166(4) has exempted certain offices from being part of the public service. And that includes office of the Speaker, Deputy Speaker, National Assembly members, President, and ministers. So that is what our Constitution is defining public service. We cannot do anything otherwise at the moment. So if they are attempting to define person employed in the public service, we have to limit it to what the definition of public service in the Constitution. Because that's what they are trying to define. Any other definition outside of that will fall foul of the definition in the Constitution.
Then why don't we just not use the word civil office? We use public office?
Or Speaker.
Why don't we remove it completely? Remove civil office is what is creating. Because it is used, the committee is right for us to have a definition.
The minister has made a clarification, and I think that suggestion, if we go by that, that instead of using civil service, we just use public service. As it is in
fact, the civil service is a subset of the public service. The civil service is part of the public service. So once you define public service, civil service is included.
Sir, this is why,
Yes.
A civil office, including the office of the president. Why don't we say a public office?
We were just going to suggest that we say person employed in the public service shall be as defined under section 166 of the Constitution.
Yeah. In public service, you know, you are talking about public service, and this one is talking about public office, civil office.
No, but this civil office, remember, Honorable Speaker, if you look at it, where we have this civil office, there are subparagraph A, B, C, and go on. But look at the root word that they are trying to, the phrase they are defining. Person employed in the public service, unquote. That's what they are defining. That is what giving us all these problems. If you just go up, the concept being defined, in quote, is person employed in the public service.
Yes.
We are saying the Constitution has already defined that for us.
So then it means that this
So
one
everything
is not,
else they are doing, we can save that by simply referring to the constitutional definition of public service. Finish.
this is what we are saying. You are now saying the whole of A, B, C, D, E, up to that thing should all go away.
Yeah, and we rely on section 166 of the Constitution.
Alhamdulillah. Alhamdulillah. Yes?
You know, I think for that, for page 15 and ABC, I think that one will suffice. But in an event that we go further and see this civil office anywhere, do you have a term to replace with?
No.
We checked its use only twice in A and C.
So in the other parts, it's not used?
Throughout the document.
Honorable, what we have, I think what the Honorable Minister suggested is very clear, all what we are trying to do is to define public service. Yeah? And that one is already defined. And then we just make reference to the Constitution and we go ahead. No more all these other nitty-gritties that are written down. Yeah, you people, but are you noting? Are you taking note? So all these ones should go. Up to where? Up to 7. Up to 7. Okay? Any more honorable members? Woolley?
The same problem with sexual act. So we say we consider the definition to be in line with the definition of the term in the Sexual Offences Act. That was the recommendation. There is a term in the Sexual Offences Act. So the definition there should suffice here.
Observation, they make the work difficult for us, I'm seeing. Because they should have just, lifted it and read it to us. So it means your work was not complete.
Chair, I think the chairperson of the Human Rights has to help the chambers. Not, they are lazy people. Swaibu.
Okay, what you are saying, Honorable Member for Woolley is, sexual act is defined. You want us to remove it and just take what is in the act.
It's the same, the definition here is the same as the one in sexual offences.
They are telling us that what is here is the same as what is in the act. Yes. Now, can you continue, please?
Chair. Honorable Woolley West East has to help us. You went for a retreat. You should be doing all these things.
Honorable members, it is proposed that clause 3 stand part of the bill as amended. Those in favor, please say aye. Aye. Those not in favor, please say no. The ayes have it.
Part 4, extent of jurisdiction of courts of the Gambia.
It is proposed that part 4, extent of jurisdiction of courts of the Gambia, stand part of the bill. Pardon? I'm saying clause 4 of part 3. Clause 4, I'm dealing with clauses. Are you clear now? Yeah, the proposal is that clause 4, extent of jurisdiction of courts of the Gambia, stand part of the bill. Those in favor, please say aye.
No, but we have a recommendation.
You have a listing, then come up.
Yes, we have a recommendation. The committee proposes that clause 4, subclause 4B, stand as part of the bill with the following amendment. 1. Is done by a person outside the Gambia who afterwards enters the Gambia instead of and afterwards.
You know what we have is when an act which is done by a person in the service of the government of the Gambia or a statutory body beyond the territorial limits of the Gambia. You want that case to read
is done by a person outside the Gambia who afterwards enters the Gambia instead of.
It's on 4B.
4B.
Yes.
Yes, but what we are saying is, you know, the original text, what we have is, when an act which is done by a person in the service of the government of the Gambia.
No, it's this one. It's this sub 4B. 4 sub 4B.
Oh, okay. Is then 4 sub 4B, yes. Not 2B, it's 4B. All right, before I invite all of you, honorable member for Woodley and Serekunda West, which one are you amending? 42B or 44B? 442B rather. No, it must be 42B or 44B. 44B. So that's very clear.
Chair, and also look at the report also. 44B.
Yeah, this is what I'm saying. Now, no more arguing about it. We are now dealing with 44B. That is the last one on the page. When an act which is done by a person outside the Gambia and afterwards enters the Gambia is to read as, can you read it again, please? Can you read it again, please? Who? Yes?
Afterwards, the who is missing.
So the and should be removed and replaced with who?
Yes.
Yes?
No, don't confuse the chair.
Who afterwards? The and should be replaced by the who.
Yes. This is what you are, that's how you read it. The and should be removed and replaced by WHO. Yes?
For Central Badu is not having the report, so he's not really following the proceeding. Get a copy of the report first. No, get a copy of the report so they can follow. Okay.
Proposal is 44B is done by a person outside the Gambia who afterwards enters the Gambia. Huh? No, Honorable, you should have your copy of the.
I'm also listening to him.
Yes, that makes
you know, when he was putting up his case, he couldn't distinguish between part 4 and clause 4. I was following you very well. It's now that you put them through.
It is proposed that Clause 4, extent of jurisdiction of courts of the Gambia stand part of the bill as amended. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Part 5, ignorance of law.
It is proposed that Part 5, Clause 5, ignorance of the law, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 6, bona fide claims of right.
It is proposed that Clause 6, bona fide claim of right, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 7, intention and motive.
It is proposed that Clause 7, intention and motive, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 8, mistake of facts.
It is proposed that Clause 8.
We have an issue.
Yes, honorable members.
The committee proposes that Clause 8 stand as part of the bill with amendment. 1, remove all the commas in line 2.
There are 2 commas. Yes. Yes, go ahead with the proposed amendments. Next one. That's all. Honorable members, all what he is saying is mistake of fact. A person who does or commits to do an act under an honest and reasonable but mistaken belief. Those commas after reasonable and mistaken should be removed. I think they have consulted with language experts. So that is noted. It is proposed that Clause 8, mistake of fact, stand part of the bill as amended. Those in favor, please say aye. Not in favor, please say no. The ayes have it. Yes, next one.
Clause 9, presumption of sound mind.
It is proposed that Clause 9.
Issue.
You have something?
Yes. The committee proposed that Clause 9 stands part of the bill with the following amendment. Replace the word which in line 2 to the word that.
Look at, yes, we change the which, yeah.
Instead of becomes in question. Honorable members, are you following? No, this one is language. Honorable Minister.
So,
because I think the proposals is the outcome of a retreat.
So it is the time that we are qualifying here.
Yes.
So when you're making reference to time, is it appropriate to use which or that? It is the time that we are qualifying here. The time, a specific time. So every person is presumed to be of sound mind and to have been of sound mind at any time. So it's the time here. At any time which or at any time that?
But I thought at your retreat you had your legal.
So I believe which is more appropriate here because it's a specific time point in time that we are referring to. It's a specific point in time. Remember, for us, in law, insanity does not necessarily have to be a permanent condition. There could be some form of insanities that can come on and off. So at the material time that you are accused of having committed a crime, you may use a defense that at that material moment, you were suffering from some form of insanity. So it's the material point in time that we are qualifying here. So I think which is... Sorry?
the word that material moment. And it's that material moment that we want to capture here. That.
I say it's a particular material moment.
That.
Yes.
Yes. That's why we think that the
No,
that
but
is
here
more-
is the time which comes into question.
I'm
I'm not too sure whether this is
My
very
question,
significant.
my question is, does it mean that which is the one that qualifies the time? What about that? Eh? Minority. I think that is the University of. So, honorable members, now we have heard from all sides. Which one do we take?
We have to take one. Or we can also use both. Yeah. Yeah, today is the first day.
But the proposal is coming from the committee that sat over it, together with the justice people. And they led the report, it was adopted. Are there new facts to it?
No new facts at all.
It's only making a recommendation. Yeah, that, the final duty responsibility is yours. No, we can reject it. We can agree or disagree. They can only inform us. Yeah, but why are we looking at it if they are the authors? Then let's give it to them.
Honorable, not that. Don't conclude like that.
You're thinking.
We rely on their expertise to guide us.
Agree, to guide us.
Yes.
Yes. But when they do, there are a lot of times when they will tell us something and we will disagree.
Yeah, but this time, let's agree.
This time you. That's why we are asking members. That's you. Are members in agreement with that?
Okay, Chair, can I say something? Member for BANJUL not?
Yeah.
BANJUL, yes. I think what the Minister of Justice have advised is the right thing, because we're talking about the time frame here. So the word which, I believe it is, I am in agreement with that word, which.
I agree too. I'm still listening. Honorable, the committee.
Chair, we went to the retreat. It's the legal people who actually did this argument, and they gave us the word that.
My concern actually is
so if they want
that
to
and
change-
which in this particular area. Does it specifically qualify the time? Yes.
The committees are an extension of the plenary. We are assigned to do it, we come back and report. The ball is in the committee's court now. Let them decide. We've tell you what we suggested. Take it or leave it. We are done.
Yes, you are right. The final decision should be taken by plenary. But we are just advising that they should take cue from the fact that this was debated by you people, taken to a retreat by you people, together with legal experts. It was debated here again by the plenary. We have to get those things into contextualize them. That's where we are. But with all that, there could be errors. If we feel there was one that we had oversight of some other things, we can correct it. So, but that one is all of you.
Commended by the ministry too. Was it too?
You see, what we are trying to say, what is being said here is that, let's read it. Every person is presumed to be of sound mind and to have been of sound mind at any time that comes in question. That means that if you commit something, and then after that, they come and, for example, test you and discover that, well, you were not on sound mind by the time you were acting. But now you went, for example, you are no more of sound mind. So we're saying anytime that comes to question, that issue comes to question, That's what we are trying to say. Unless you are trying to. Yes,
Are you still suggesting that we change the week to that? That's what you are saying. That's what you are still.
Mr. Chair, that was total, I think that was the rationale behind, and we agreed with the recommendation of the ministry then that we should change it to that.
Central Badibo, it looks like people are saying
And
we
also
change it to
Banjul
that.
not. And also Banjul not.
And Banjul not.
Yes. I am
Except for
still
those two.
saying which is the right word.
Yeah, we've had it now, except for two of you. That's what I know of. Honorable, you don't dictate me. You are dictating. No, you are dictating. What I do know so far, I said, is you and him. No, if they are more, they have their mouth, you said yours. That is not your deal. That is not what you should do. That is not what you should do. You talk, that's why I knew. No, I'm not concluding. To the best of, that's why I'm inviting people to talk. So somebody was talking there. Is it Nyani or Nyani?
Yes,
Nyani,
yes, Honorable Chair. I was just doing some other place. Majority. I was just doing some little research on this, that, and which. You see? And then I think it's important we say it says that is used to introduce restrictive clauses, while which is used to introduce non-restrictive clauses. So my advice is let's do as drafted here. We go with the which.
Chairman.
What to do, because I don't want to put it to a vote. I want us to be convinced. Yes, Sammy?
Yeah, thank you very much for the floor. Chair, I'm also recommending it to leave it at that, because which refers to non-living things, and that refers to living things. Yes. As that.
Honorable, I am now getting more people who are saying we leave it as it is. Is that what is in the general trend?
I am part of those who are saying we leave it as it is. Weak, yes.
Chair, I think I suggest we leave as it is, because when we look at the, both that and which household, they all have their own definitions, but this in legal term should have a meaning in connection to the sentence. So using which I think will suffice.
All right, honorable members, I think what we can finally do, which I don't want to do, is to ask those who are in favor of leaving it as it is against those who want it amended. Now, those who want it to be left as it is, that's using the word which, please, let's see your hands up, your tags up. Help us quickly. Those who, honorable, those who want it changed to that, big to that, raise your tags. Those who want it changed. Five against. Those who are abstaining. Those who are abstaining. Who? One. One abstention, huh?
One, yes. What is that? Does it ask?
Honorable members, our figures don't tally. You either voting yes or no, or you are absenting.
Chair.
Please. I think we have to change seats. You come and sit here. Yes?
You know, I voted neither no or yes because I said I've submitted because I agreed to the voice of the majority. So I'm nowhere. I'm not going to vote.
It's abstained.
My tag anywhere and I'm not. No, I will not. Because I don't want to. It's my right.
Whether he raised it or not, we count him on the abstention.
Honorable members, your views should be heard and known. You owe it to the people. So no, or you are abstaining.
That is my right. Now you decide where I am.
Chair.
It is that's using the word which is 13. Those who want it changed to that 5, and then only one tag. We have counted only one died at the time. One raised it. So it means we are going to leave it at which. It is proposed that clause 9, presumption of sound mind, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes.
Clause 10, persons of unsound mind.
It is proposed that clause 10, persons of unsound mind, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 11, intoxication.
It is, yes, honorable members.
Stands part of the bill with the following amendments. 1, subclause 2, line 4. If you have the bill, subclause 2, line 4, it says, he was doing. And that he, we say he, she, he or she, instead of just he. That's the amendment there. And subclause 2B, subclause 2B, yes, 2B in line 1.
Why are we putting he, she everywhere?
Well, this is modern language. You will always put he, she.
No, but I think these are interpreted already. Now, when you use she or he, it means he, she.
No, we don't accept that interpretation now. We want to take
definition.
No, we want to take care of both sexes. We don't want to take one. That's not the language now. We've changed that in English.
You change what in English?
Yes. This committee, we put he, she in all the places. So, 2B, Honorable Chair.
He, she is not a language. We better use another language for it.
Huh? But Chair.
He or she.
Chair.
Yes?
Chair, this was laid in your presence here. This is what the plenary agreed. Now you are raising issues with that. Leave it as it is. Let's leave the sleeping dogs to sleep. If you have agreed.
I am not comfortable. That's why we are agreeing. That's why we prevented the committee's recommendation. Why didn't we strike it out? just now. Why don't you comment when that was done? Yeah, but what I'm saying is, you were here when they were here when that proposal was done. They never said anything, but they changed it now. Yeah, I think we can continue, isn't it? So does it mean wherever it occurs in this thing? Because it means wherever he occurs, you now make it he or she. That's how?
Most of the places.
Ah, okay.
Yes.
It's only in special omitted areas.
Yes.
All right.
So clause 2B line 1. 2B line 1, the word insane should be replaced with unsound mind. You see English, we've changed insane now. We're putting unsound mind. The word is getting modern. Yes, 2B. Yes. The word insane there, the word insane, you see that? We'll change it to unsound mind. Unsound mind. Yes, it's human rights language. Huh? Yes.
No, but if you want to use unsound mind, would it work?
With unsound mind? Yes, it will work.
Read it. Read your your proposed amendment.
My proposed amendment. Passing charge was by reason of intoxication of unsound mind.
You see, you have to add something again. That's why I said.
Passing charge. Passing charge was by reason of intoxication.
That's why in this particular issue, maybe the insane is the appropriate word.
No. You can. Why don't we put off there, of unsound mind? What's wrong with that? We can add that there.
Passing charge by reason of intoxication. We remove was. Remove was by reason of intoxication of sound mind, temporarily or otherwise. Yes, that's it. That's how it is. That's how it is. Temporary or otherwise, are you going to remove it? It's there already. Honorable is talking. No, it's correct. No. Passing charge by reason. You remove what? Remove what? Passing charge by reason of intoxication. Huh? Yeah. Of sound mind. Then you continue with the rest of the sentence. Intoxication is there. Huh? Huh? Reason. Okay. Yeah, it could be reason. I was saying passing charge.
I said, you want us to remove the first word was.
Was, yes.
Let me read it and whether it's correct.
Yes.
Passing charge by reason of intoxication was insane.
Of sound mind.
Okay. I thought you were saying
No,
was
of
insane temporarily or otherwise.
Yes, of
Okay.
sound mind.
You remove the the was, and then you put off in between intoxication and
Yes, of unsound mind.
Yes.
Chair, I think the word was is the most appropriate one, because when you think of the word charged, which is past tense, then words suits best, I think. Yeah. Charging, passing charged, which is past tense, was by reasons of any amendment that he would like to do. But I think what was suits best here because of the word charged, which is past tense. Thank you.
You must read it against the number 2. It's a continuation of number 2. It must. Because if you look at number 2, the last, such an act or omission was wrong or did not know that he or she was doing, and the person charged was by reason of intoxication, insane, temporarily or otherwise, at the time of such an act or omission. Yes?
Can I suggest, I think we just put comma after intoxication, and then we put on sound mind temporarily, then it goes. We just put comma after intoxication. Person charged was by reason of intoxication, comma.
The problem is we don't want us to use the word insane. You want us to use the word unsound mind. Am I right?
Speaker,
Yeah.
Chair.
Yeah.
This is because insane as just mental illness. No, there's another definition to insane also, different from madness, and it's correctly used for me. Yes, because insane is in a state of mind which prevents normal perception, behavior, or social interactions. So maybe the drafters are using this meaning of insane. So it's correct. There's nothing wrong to change this thing with the.
It looks like the two are not the same completely.
Chair, I tend to agree with Honorable Member of Talindi. You know, for a bill to be referred to a human rights committee, it doesn't mean that all the terms there should be human rights friendly. So there you have to look at the context. So the way Honorable Member of Woolley is speaking, as if all the terminologies and terms should be, you know, human rights oriented.
No, it's not that. The insane.
Honorable Chair.
For Talindi, where did you have your definition or you read something? You read out something as a definition.
Several meanings. It's not just one meaning. It has. Yes. So I have an online dictionary I was referring to. So if you look at it, it has 3 or 4 meanings. So one of the meaning is insanity, yes. But then this first meaning, number 1 meaning, is when a person is in a state of mind which prevents normal perception, behavior, or social interaction. You know. So now why do you now have to change it? It's not mixed. It's not mixed. No, it's not mixed.
Honorable Chair.
All right, can we do it this way? Can we compromise, Honorable
Yes,
Member?
Honorable Chair.
If you look at 10, we are dealing with 10, 11 now, isn't it? You look at 10. 10 is persons of unsound mind. And you come to 11, intoxication. So it looks like for it to flow, we can instead of using insane, we use unsound mind. Oh, my friend, that's what I'm trying to convince people to accept. Your recommendation may not hold water if we don't accept. So we are trying to convince each other. We are trying to find ways to, yes.
Honorable Chair.
Yes. Nyanija.
I think we are just getting it more complicated. And then, with all fairness to the Human Rights Committee, in their human rights lenses, I think once we change the word from insane to unsound mind, it's a bit more human rights friendly as far as their language is concerned. But to me, what is more apt is to leave it as it is. Put the insane there, and everything will flow. Because if you look at the provisions, the clause here, from intoxication to the heading, you come to subclause 2, you read everything is flowing. But once you change the insane to unsound mind, you definitely have to listen. I think it is better we leave it as it is.
You know, I've advised that even legal people are now trying to use of unsound mind instead of insanity. Insane has been one that you use, but now they are gradually moving away from it to use unsound mind instead of insane. So, do we agree? So, but then it has to be corrected. Passing charge was by reason of intoxication, of insane, of unsound mind, temporarily or otherwise, of unsound mind should be added. Temporarily or otherwise, at the time of such act or omission. It is proposed. Do you have any on clause 11?
Yeah.
Huh? Sorry. You said what? All right, honorable member. Yes, you move to 5.
Of that same clause 11, subclause 5, second line, there is a word there, produce. We want to change that word to induced instead of produced. So it will.
For the purpose of this section, intoxication shall be deemed to include a state produced by narcotics or drugs, induced by narcotics, yes. Are we fine? Induced. It looks like you have done a good job, the Human Rights Committee. Yes, they have gone into nitty-gritties, small things. Honorable CJ. AG.
Honorable Speaker, we noticed the same clause 11.3. If you look at it, there is a cross-referencing referring us towards the end, section 188 of the Criminal Procedure Act. We just checked. Under the current Criminal Procedure Code we are using, there is nothing like section 188. We checked, it appears the drafters are trying to make reference to the counterpart of this bill, which is the Criminal Procedure Bill, which is before you, but not yet enacted. But even there, the cross-referencing missed the point. It didn't refer to the right section. So, but because you cannot refer to a bill that is not yet passed, because we don't know whether that section they are trying to refer to will survive or not, we are proposing an improvement on that clause 3 because we understood what they are trying to do. If you look at clause 11, it is saying it is the defense of intoxication. 1 and 2 lead it out. and you have A and B. So 3 is trying to say where you succeed in the situation of paragraph A, what should apply is acquittal or discharge. Not acquit, but discharge. Then it's trying to say if it is in situation of paragraph B, the procedure that should apply is the procedure of when somebody is already found to be insane. And in the criminal procedure, we have those procedures. Every criminal procedure will have that procedure. But they are trying to specifically refer to a section that doesn't exist. So we are proposing this now. The new 3 that we are proposing shall read.
The new 3?
Yes, that we are proposing.
Now, meaning we're going to remove, that will replace the whole 3, all these 3?
Yes.
Yes, okay.
So
okay.
we are proposing.
Okay.
It's to read where the defense under subsection 2, where the defense under subsection 2 is established.
Where the defense
under subsection 2 is established.
Subsection 2
is established.
Yes.
In a case falling under paragraph A. Yes, those are there already.
In a case
falling under paragraph A thereof.
Falling
under paragraph A thereof.
Paragraph A
thereof. The accused shall be discharged. We have that. We are not touching that.
Thereof.
Thereof, yes, the accused shall be discharged. And in a case falling,
the accused
shall be discharged.
Shall be discharged. Yes.
The accused shall be discharged. You got that?
Yes.
And in case falling under paragraph B thereof.
Under.
Yes, and in a case falling under paragraph B thereof.
In a case.
The procedure outlined under
paragraph C.
B, yes. B.
Thereof.
The procedure outlined under the criminal procedure law.
The procedure
outlined under the criminal procedure law.
Outlined.
Criminal procedure law. With respect to an accused person.
Criminal procedure law.
With respect to an accused person. With respect to an accused person. Found to be of unsound mind shall apply.
Found to be
of unsound mind shall apply.
Unsound mind shall apply.
Shall apply. So let me give a small explanation for the rest of the members. Now, in situation in A, it says the state of intoxication was caused without his or her consent by the malicious or negligent act of another person. This is where I think the Ndongos will say spike. When somebody makes you intoxicated without your intention, whichever way it happened. But the most common way, you put something in somebody's either drink or something. So he did not get himself intoxicated, but through an intervention of a third party. If that is established in a proceeding, that is discharge. That's A. In B, is there where passing charge was by reason of intoxication on sound mind, temporary or otherwise, at the time of such an act or omission. Now, if it is not proven that it is caused to you by a third party, but the intoxication itself caused you some form of insanity, then they say the intoxication defense will be now put aside. It's the procedure of insanity that will kick in. Basically, that's what we are saying now. Because intoxication have led you to become insane. So therefore, the procedure for people that are found to be insane will kick in. So we are now trying to refer to whichever that procedure is under the procedural law will kick in. Instead of specifically saying 188, we run the risk of missing it, because if the procedural code is passed later and that 88 did not exist, that would be a problem. So we are making a generic reference here. So referring to any procedure that applies to insanity will apply mutad, like the lawyers will say, mutatis mutandis. So, but we avoid the Latin words and say that procedure will apply in this case. I hope it's not too, it's easy to understand. I think.
If we understand you, the first one you talked about is if the intoxication or whatever is induced, meaning somebody did it to somebody, then you discharge. And this one, if intoxication, even by yourself.
By yourself.
But it made you insane.
Insane.
It's no more intoxication.
Yeah, defense of insanity will come. And there's a procedure for that.
Okay.
Yes.
Do we follow? Honorable members, it is proposed that clause 11 stand part of the bill as amended. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 12, immature age.
Clause 12. It is proposed that clause 12, immature age, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 13, immunity of judicial officers.
It is proposed that clause 13, immunity of judicial officers, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 14, compulsion.
It is proposed that clause 14, compulsion, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 15, necessity.
It is proposed.
We have an issue with 15. The committee proposes that the word evil in clause 15(1)(b).
The word?
Word evil.
Evil.
Yes, in clause 15(1)(b).
Yes.
In line 4.
Yes.
Be replaced with the word harm. H-A-R-M.
An act or omission which would otherwise be an offense shall be excused if the person accused can show that no more was done than was necessary, was reasonably necessary for that purpose, and that the evil, that you mean now is to say the harm inflicted by it was not disproportionate to the evil. We will change both evil, these two evils to harm. Evil inflicted to the evil avoided. What will be there? To the harm avoided? Yes.
Evil in line 4. Well, we have line 2 and line 3 in B. There's no line 4.
Pardon? Yeah, but what we have now is in B on the bill, is line 2 and 3. And that the evil there should be changed to harm. In both of yours.
It makes sense. In fact, no.
I think the honorable member for Central Badminton can read. But I read it. It is proposed that clause 15, necessity, stand part of the bill as amended. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 16, use of force in effecting arrest.
It is proposed that clause 16, use of force in effecting arrest, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 17, defense of person or property.
It is proposed that clause 17, defense of person or property, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 18, compulsion by husband.
It is proposed that clause 18, compulsion by husband, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 19, person not to be punished twice for same offense.
It is proposed that clause 19, person not to be punished twice for same offense, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 20, responsibility of person who has charge of another offense.
It is proposed that clause 20, responsibility of person who has charge of another, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 21, duty of head of family.
It is proposed that clause 21, duty of head of family, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 22, duty of principals.
It is proposed that clause 22, duty of principals, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 23, duty of persons doing dangerous acts.
It is proposed that clause 23, duty of persons doing dangerous acts, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 24, duty of persons in charge of dangerous things.
It is proposed that clause 24, duty of persons in charge of dangerous things, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 25, duty to do certain acts.
It is 25? Yes, 25?
Yes, so Chair, the issue here is that the committee says this is proposing to the ministry to look into this thing and break it down because it's a long, cumbersome paragraph. So how they can break it into smaller sections to help us better understand. That's the only proposal there. That the sentence is
a
very
person
long.
who undertakes to do any act, the omission to do which is or may be dangerous to human life or health, shall do that act, and he or she shall be deemed to have caused any consequences which adversely affect the life or health of any person by reason of any omission to observe or perform that act.
Yes.
For them, it's not a problem. No. That's what for us, yes. Because even if we are to do it now, we have to wait until it is done before we can pass it. Honorable Minister, you have any? I was just told that you people are comfortable with the language. I don't know. Can you comment?
Is it close? Yes, I think any lawyer will be fine with this. But we owe it to you for you to understand it. But for the purpose, it is fine. A person who undertakes to do any act, the omission to do which is or may be dangerous to human life or health shall do that act, and he or she shall be deemed to have caused any consequences which adversely affects the life or health of any person by reason of any omission to observe or perform that act. You want to split this, you're gonna get into issues. It's better we keep it all together. If you have a responsibility, it can be split, you can split it, but we are better off holding it together. That's what we would recommend.
Honorable? Okay. It is proposed that clause 25, duty to do certain acts, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 26, principal offenders.
It is proposed that clause 26, principal offenders, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 27, offenses committed by joint offenders in prosecution of common purpose.
It is proposed that clause 27, offenses committed by joint offenders in prosecution of common purpose, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 28, counseling or an order to commit offense.
It is proposed that clause 28, cancelling an order to commit offense, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 29, definition of accessories after the fact.
You have an issue?
It is proposed.
You have an issue? You have a suggestion?
Yes.
The committee proposes that the word accessories be deleted. Yes. It is the opinion of the committee that the title accessories after the fact suffices and that the definition of should be deleted. Definition of, meaning from definition to of be deleted and then just leave the accessories after the fact. It's enough.
I don't understand.
You don't understand?
The heading 29.
Yes, heading 29.
Should read
accessories or accessories after the fact.
Okay, the word definition of should be removed.
Yes.
Okay. What, honorable members, what they are proposing in 29 is the first two words, definition of should be removed. The heading now becomes accessories after the fact. Do you follow? No more definition of accessories, but accessories after the fact. Honorable Minister. Honorable members, so we remove 29, we remove definition of. The A will be capital. Yes. Honorable members, it is proposed that clause 29, accessories after the fact, stand part of the bill as amended. Yes?
A person who receives or assists another who is to his or her knowledge committed an offense.
Honorable Speaker, maybe can we eliminate IS after who? And then we read it again. The first line towards the end, where we have who is. Can we remove IS and then read? It might.
Another, who to his or her knowledge,
Yes.
that it should be out, isn't it?
Yes. Yeah.
Okay? Thank you, Honorable. It is proposed that clause 29, accessories after the fact, stand part of the bill as amended. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 30, incitement.
It is proposed that clause 30, incitement, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 31, offenses by corporations, societies, etc.
It is, yes, you have comments, okay.
Clause 31. Our recommendation is that if you look at the sentence in B, 31B, we are saying there should be a comma after any director, comma, there should be a comma after the director. And in the second line, where you say knowingly directs, should also have a comma, then authorizes, etc. Then it flows. You've seen it.
Members is on 31B. Any director, comma, manager or officer of the body corporate who knowingly directs, comma, authorizes or suffers the commission of the offense, continues, huh? So these are the two commas. Any director, comma, and then directs, comma. It is proposed that clause 31, offenses by corporations, societies, etc., stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 32, different kinds of punishments.
Yes. We have
It is,
suggestions.
okay, yes.
We have a suggestion. The committee suggests that the caption, instead of different kinds of punishment, it reads types of punishment. No, types of different punishment. Be replaced with types of punishment.
Punishments. No more different and no more kind. Okay. The proposal, honorable members, is 32. The heading is different kinds of punishments should be replaced by types of punishments. Honorable AG. It is proposed that clause 32, types of punishment, stand part of the bill as amended. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 33, sentencing rules.
It is proposed that clause 33, yes, issue, yes.
Sentencing guidelines instead of rules. That's the recommendation. Instead of rules, it should be guidelines. That's the
Then does it follow that the chief judge, the chief justice may make guidelines instead of rules? I mean, then it means we have to go inside to change those things. Yes. Because it says, number one says the chief justice may make rules in respect of sentencing of convicted persons, in particular on the following matters. So it is sentencing rules. So if you say sentencing guidelines, then we will have to change this to say the chief justice may make guidelines.
No, then let's leave it as it is.
Honorable? Yeah, but now the agreement is, can we leave it as rules? regulations, etc., or order. And this is going to be subsidiary legislation, basically. We are getting those facts from them. Honorable Minister, I think we leave it as it is, rules. They are suggesting we leave it as rules. Yes. If you want it covered in the whole process, because if you talk about guidelines, you know, so, where is it? Which one are we dealing with? It is proposed that clause 33, sentencing rules, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 34, imprisonment.
It is proposed that clause 34.
I have a suggestion.
Yes.
The committee proposes that clause 34 stand part of the bill with an amendment. That is the phrase hard labor in 34. Subclause 1, line 3, be expunged. 1, line 3, hard labor.
Line 3?
Yes, hard labor.
All right.
Be expunged.
All imprisonment for an offense against this act, against any other law, may be with or without hard labor in the direction of the court, unless the imposition of imprisonment only without hard labor is expressly prescribed by law. He said we remove hard labor.
Yes.
Saying,
Honorable Chair.
Yes, please.
If you are saying without hard labor and we remove the word hard labor, that means it should be substituted by something.
To give
that
meaning.
Has to be only without what? Huh? If hard labor had to be removed, so only without what is to be substituted?
The argument around it is you can just sentence them to prison, but then there should be nothing like hard labor.
Is that the meaning?
Yeah.
Yes.
The new bill is recommending that there should not be any hard labor. Yes. And that's why we are saying it should be.
Yeah, but if you look at it here, it's not only that portion. If there is hard labor mentioned, all imprisonment for an offense against this act or against any other law may be with or without hard labor. In that case, we are saying that so far no hard labor, then that this whole thing should go out. Because they are saying that imprisonment of these categories may be with hard labor or without hard labor.
Is what should be there.
You see, then there is no need for the sentence. Because why the sentence is couched that way is because it's giving you alternatives. So where there is none, it's only that one, then there is no need for the sentence itself.
Chair.
Yes?
What the committee is looking at is the bit of the hard labor. So that even not only here, anywhere else we come, now hard labor need to be expunged from the, anywhere in this act, we'll expunge the hard labor there. When somebody is sentenced to prison, let him just be sentenced to prison. Without hard labor.
Yeah, but that should inform the whole language structure of the bill. But where at the conviction you can be sentenced to hard labor and all these things, all those things have to change. Because if what you are saying is correct, or we take it that way, then there may not be this paragraph may not even be necessary. It is obsolete. Look at it. Yeah, they are saying that no option of hard labor. Human rights.
Actually, the position of the committee is the sentences will be without hard labor, no sentence with hard labor.
Yeah,
that's the spirit.
Without hard labor, you cannot say that we should expunge hard labor.
You know, I think the whole thing here is, all what the committee is trying to suggest is, there should be no more sentencing with hard labor. Basically, all sentences should be sentenced. No hard labor, no other this. This is why they want this hard labor expunged. But rather than expunge it, we should remove the whole sentence. With the whole this thing, it has no bearing anymore. Honorable AG, can you? Yeah, can we listen to their opinion?
Not with hard labor. Sorry.
What Section 34(1) is saying, unless expressly prohibited by statute, the discretion to sentence somebody after conviction with hard labor or without hard labor is vested in the court, is leaving it to the discretion of the court, whether you should go with labor or without hard labor. And, but your authority as lawmaking body has not been removed. It says anytime you are prescribing a sentence and you think those kind of sentences should not attract hard labor, specifically state it there. But if you don't state it there, the principle, the court can decide whether, as at the time you are convicted and sentenced, it should add hard labor or it shouldn't add hard labor to the sentence. So from what I'm hearing is, you are proposing that there should not be any hard labor imposed in our jurisdiction after a sentence. Is that your sweeping position? That position is informed by what? I am curious. Yes. Why would you want to eliminate hard labor as a form of punishment in our penal code? Because that means you are radically saying that the courts will no longer have authority to impose hard labor after sentence. If that is your position, I'm not too sure whether you have provided us what informed that. Because that's a radical departure.
Well,
Yes.
it's a kind of enslavement, because if I have a conflict with the law and I'm sentenced to prison, and upon that you said I should do hard labor, and I'm not paid of that as well, it means that that's slavery.
Yes.
That's slavery. Because you are forcing the person to do a labor that he will not earn anything. So as a result, let's just sentence them to prison. That's all, without hard labor. That's the position.
Yes, you are sentenced to prison and at the prison you are asked to go and fetch firewood.
Honorable Chair. That's not correct. That's what?
That's hard labor. No, let's hear opinions. And you know why I don't want us to go deep into this? For us to effect this one, meaning removing hard labor from our statutes. It's not here. It should be removed from somewhere else. You know what? I don't know. If you remove it here, it does not prevent a judge from sentencing you to hard labor.
Swaibu, not like human rights. Once you commit an offense, your rights, some of your rights are no more longer there. If you commit an offense, your rights are no more longer there. Some rights are seized. What do you mean human rights?
Honorable, I think your query is, Honorable, please. No, yes, no. Honorable, I think your plea is actually because you feel that people's know is slavery for you to be forced to do something that you are not paid for against your wish. Am I right? Honorable Wuli Serekunda West.
That's my conviction.
Yes, but if you look at section 20 of the Constitution, 20, protection from slavery and forced labor. No person shall be held in slavery or servitude. No person shall be required to perform forced labor. For the purposes of this section, the expression forced labor does not include any labor required in consequence of a sentence or order of court. Now what I'm saying is, here, it means by the Constitution, it can be done.
Yeah, it's not wrong.
Yes, it's not wrong. So if we, as legislators, I think we must be holistic, we must make a wholesale decision. If we feel that there should be no forced labor, let me learn. No forced labor at all. I think we look at the root of it and then pull it out. Yes, before you come, let's hear who? Kiang West.
Chair, what we understood from what you have just read, that is, and in case anybody is sentenced by a court order that you will serve that sentence term with a hard labor, that it excludes that. But in case, you can prevent it also. You can prevent it. It is not saying the court must do that. It is not saying that. It is telling you in case you are sentenced by court, to serve a prison term with a hard labor, that section is telling you it excludes that. But these people are telling us now, we want to prevent that from happening now. To say in this case, you shall not be subjected to hard labor. This is what these people are submitted.
Well, I understand you. What we are saying is, if you want that removed, you go to the root and remove it, then it will satisfy all others. You go to the root cause and say, you cannot be convicted with hard labor anymore in this country. Unless you listen also to people, you will be arguing over the same thing. This is specific. It cannot be specific. Where others it can be done and this one it cannot be done. Where will you have that? The idea behind them, the logic is they believe that for people to be convicted with hard labor is more of enslavement, and that it should be removed, and that people should not be forced to do a job that they are not paid for. I think that was your contention.
Personal, but the committee's rationale was that is double punishment.
Honorable, just wait, hold on. Let him come in and then you come in. Yes?
I'm trying to say what you are saying. For us, we want to agree with that. Since if it is in the Constitution, and then we change it here, it's like it's of no effect.
Thank you.
So we want to submit that we maintain it there.
Yeah, and in fact, I am not against that it be removed.
Yeah.
What I am saying is, if it is to be removed, it has to be holistic. It has to be directive that it cannot be done. Whether it is here or not there, you cannot do it. That prevents it. But you have many statutes around. You are removing only this one. Others can do it. What else? Exactly. So that would create a problem.
Thank you, Chair. Chair, you see, the forced labor under normal circumstances should not be removed for various reasons. One, the individual have committed an offense. Two, the individual is fed by the state. The individual is accommodated by the state in the prison. So we have given him enough. So if the individual is actually subjected to hard labor because of the crime committed, I think that should be part and parcel of it. We are even thinking of, in fact, sending them to Janjambure for them to go and farm for us because we cannot continue to feed them as a nation. That is my stand.
I think we fun like Nekasa. Fun like where are we?
34.
Honorable members, I that if this house so feels that the forced labor should be out, let's task our legal department.
Nominated member.
Yes, who? Banjul South.
I'm trying to, what I'm saying is that the committee, the rationale behind the committee's decision was that it would be seen as double punishment. And it is stated that a crime, you shouldn't be punished twice for one crime. I think that was the rationale behind it. Yes.
That is best practice in the world now.
Yes.
You don't jail people and, ask them to go and do hard labor. That's.
Yeah, the committee is saying, the committee did their submissions. And they honestly said it means it's derogatory enslavement. Now, it should not be in our statutes. People should just be sentenced. That's what they are saying. But there should be a holistic approach to it. Yeah, you look at it, you still have the right, because whoever prepares it, it comes to you for approval. Who?
Nominated member.
Honorable nominated member, Keba Lang Fofana.
No, it's okay. Since we are in agreement, I think we can move, Honorable Speaker. I withdraw. Thank you.
Thank you very much. It is proposed that clause 34, imprisonment, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 35, fines, costs, and compensation.
It is proposed that clause 35, fine, yes?
No.
You have something? Yes, 35, yes, please.
Yes, thank you. Chair, clause 35, if you look at the tail end of the bill, where it is saying,
Which section? Clause 35?
Clause 35, the committee proposed that clause 35 stands part of the bill with the following amendment. That the phrase in A, but 1A, clause 1A, you see the tail end of that clause 1A is saying, but shall not be exhaustive. We are saying that needs to be drafted to determine the limit of exhaustiveness there. Because if you just say it shall not be excessive, maybe the courts know what is excessive and what is not excessive. But can we
read it, please? Where a fine is imposed under any law, pardon? Number 35(1), where a fine is imposed under any law in the absence of express provisions relating to the fine in such law, the following provisions shall apply. A, where no sum is expressed to which the fine may extend, the amount of the fine which may be imposed is unlimited but shall not be excessive. Now you want to know you don't want to leave it to the judge to make that determination. He should be guided. He should be given, it can vary from one person to the other, but they should be within brackets. Yeah, the best legal people are people who don't open everything up for everybody.
Honorable Speaker.
Yes.
For almost every offense prescribed by law, you do your best as legislators to state a fine and a specific sentence. But this part is saying the rare, unlikely events where we have offense and no specific fine is stated. These are in the rare situations. In that case, what is excessive, we have to trust the discretion of the court. However, if you go further down, you will see a tabulation right under sub 5. The paragraphs goes on up to paragraph 5, you see a tabulation. That is enough to guide reasonableness. What is excessive, what is not, because there's indication there on the part of legislators that this is what we are looking at. A fine not exceeding 5,000 should not attract more than 14 days, 10,000 to 100,000 1 month. So with this table now, the court can study this and determine what is excessive, what is not excessive, because already there is a guide.
I sincerely believe in his doctrine. Usually you say in law, when you say not exceeding, people feel comfortable. Not exceeding. It means whatever, the drafters know that you will not pass that amount for that crime. But when it goes to not less than, the ceiling is the sky. There it can differ from one person to the other, with no guidelines. But in this specific issue, Honorable, I think with this one, if that will be used as guidelines, it should be able to inform the judge as to what excessive may mean to him.
And I can assure you, Honorable Speaker, and the members, that even where the sentencing is left open, completely open, you can appeal against the sentence alone in criminal procedure. And the court above can review a sentence and tell the judge below that we agree you convicted, but your punishment is above, is firm, is excessive. So you can appeal against sentence alone. And the higher courts can regulate the lower court if they believe they were excessive in their punishment.
Well, Honorable, most people cannot even get to the low courts. They don't have the means to go there. They don't have the means. So it access more so to go there to appeal again. Yes, that's the difficult side. But I think your explanation, for me, Honorable, his explanation on the tabulation on the next page should be able to inform, yeah. Are you fine? Okay. Yes. That is good work. Sometimes you in making laws, it's good that you are very careful. It is proposed that clause 35, fines, costs, and compensation stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 36, security for keeping the peace and be of good behavior or to come up for judgment.
It is proposed that clause 36, security for keeping the peace and be of good behavior or to come up for judgment stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 37, forfeiture.
We have recommended.
Clause,
We have something.
Yes.
We have something on that. Clause 37, the committee proposes that clause 37 stand part of the bill with the following amendment. 1. Clause 37 should be redrafted as 1. If a person is convicted of an offense under any of the following sections, namely Sections 79, 80, 81, 95, 96, and 97, the court may, in addition to or in lieu of any penalty which may be imposed, A, order the forfeiture to the state of any property which has passed in connection with the commission of the offense, or B, if the property cannot be forfeited or cannot be found, order such sum to be paid as the court shall assess as the value of the property. 2, any property or sum forfeited by an order of the court shall be dealt with in such a manner as the minister may direct. And 2, clause 37, subclause 3 be amended by deleting the word "shall" immediately after the word "sum."
Okay. Now, the first one you have the amendment in A. Yes. 37(1)A. And it looks like you want it to stop at offense. Yes. The second line. Yes. And then the third and fourth lines go. Yes. Am I right? You are right, yes. Are you following me?
Yes, I'm following you.
Okay.
After A, you have O, then you have B.
Yes, then that's A.
Yes.
The third and fourth lines go. Yes. Then B, what is your proposal?
B, if the property cannot be forfeited or cannot be found, order such sum to be paid as the court shall assess as the value of the property.
That remains as it is.
Come again?
That one remains as it is. B.
Yes, except that with commas.
Where, okay. Can we have your commas? Where are your commas?
Let me read again. If the property cannot be forfeited or cannot be found, comma,
yes.
Order such sum to be paid as the court shall assess as the value of the property.
Yeah, the comma is already there.
It's the same. So it's the same. No change.
No changes.
Okay. Then the number 2. Any property or sum forfeited by an order of the court, that's changed there. Yeah, it starts with any property or sum forfeited by.
Instead of a sum. Instead of a sum. So it's any.
It starts. Huh? It starts with any property.
Yeah.
Any property.
Yes.
Or sum.
Any property.
Or sum. Then the sum starts from sum.
Chair.
Or sum.
Yeah.
Yes.
From sum, then it remains sum of the forfeited by an order by a court.
Any property or sum so
By
forfeited.
order.
It's all mixed up.
By,
Let
no.
me help.
No, wait.
This one.
No,
Chair.
number 2 starts with any property.
No.
It starts with any
No,
property.
that's our recommendation.
Yes.
But I'm saying what is here. Is,
The
you know,
payment.
Chair. 2, what we are recommending is to redraft it. Yeah? The way it is there, we don't want it to be there in that way. We want to redraft it. And the redraft we want to put there is any property or sum forfeited by an order of the court shall be dealt with in such a manner as the minister may direct. That's how we want it. But what is there is that the payment of a sum, is different from what we are recommending. Yes. Yes. Or sum. Or sum.
Sum.
Yes. Forfeited.
So forfeited. The source should be out.
Yes, out.
Yeah, the source should be out. The source should be out. And then what should be added there is by an order of the court.
Forfeited.
After forfeited. By an order of the court.
By an order
of the court. Yes.
Of the court.
Then it flows again, shall be dealt with in such a manner as the minister may direct.
Shall be dealt
with. Yes.
With in such a manner
as the minister may direct.
Yes.
Chair, this suggestion, the proposal by the committee, so it means if it starts with any property or sum of, no, any property, the payment of sum of, the payment should be included. You cannot take out the payment. And in his submission, it seems that he has excluded payment. So any property or payment of the sum, the reason why sum comes in is the payment. So you cannot exclude payment and just jump to sum. Any property or sum of, no. Payment should be part of it.
Two things.
Yeah.
These people included property. Property was not mentioned.
Yes, but now they include.
They are talking about any property or sum
or payment of sum. Payment of of a sum.
There is forfeiture here. They are what they are saying here. A property is now the new element added, and a sum, not payment now, that ordered by the court to be dealt with now. That any sum, any amount that the court deemed fit for that particular thing, that equivalent to the property, then shall be directed by the minister. Yes.
Yes, honorable member.
I think they went for retreat, and this is what they agreed.
What we are trying to capture here, if you look at B, before we come to 2, if you look at B, property is captured there. If the property cannot be forfeited, that's captured. What is, or cannot be found. Now, the 2, we want to mention the property as well as the sum. Yeah, the property,
yes,
or the sum forfeited.
All right. Yes, Kiam West.
Honorable Chair, what we understand about this is talking about the payment of the forfeited sum. That payment, the manner to pay that one should be directed by the minister. This is what it is trying to tell us here. It is trying to tell us the payment of the forfeited sum. That the payment of that shall be directed by the minister. That's what it is trying to tell us. And I think this one is very clear. If they want to include another sub-clause, we may discuss that. But there is nothing wrong with this one.
They are trying to look at both A and B, and then in 2, they try to capture their thoughts in that. Now let's have Honorable Minister. Honorable Minister. Honorable Minister, are you aware of the proposal for number 2? Honorable? Are you aware of the proposal? They have made a proposal.
Yes, I'm looking at it, but...
Have you got it?
Yes, I have the report with me.
Okay.
If we look at the committee members, if we take a look at 37(1)A.
37(1)A. Yes.
The new 2 that is being proposed, is it not catered for there? Order the forfeiture to the state of any property which has passed in connection with the commission of the offense, and any property or sum so forfeited shall be dealt with in such a manner as the minister shall direct.
But their proposal in that one is that from offense, that's the end of the second line, the order should go out.
And be brought, the rest should, or they've changed that?
Yes, and they said pass in connection with the commission of the offense. That's where it ends. And any order, and any property or sum so forfeited, etc., should be out. That's their proposal.
So now we edit 2 now to say
they
any
edited
property.
2 now to take care of it. That's what they did.
Okay, any property or sum.
Yeah, they said any property or sum forfeited by an order of the court shall be dealt with in such a manner as the minister made that.
Comes to the same thing.
Yes, that's what they are proposing.
Hello? Observation.
All right.
All right. Yes.
Chair.
Yes.
The initial proposal of amending A, why not, we maintain that and delete 2? Yeah, we maintain what is in A, 1A, and now forget about 2, because 2 seems like a duplication. What is written in A?
Look at B, saying the property cannot be found, and it's not C. The value of it, you can be ordered to pay the value.
Offense, to second line offense is removed. And then you have 2 amended to read any property or sum forfeited by an order of the court shall be dealt with in such a manner as the minister may direct. Replaces 2, and then we are fine.
I think, Honorable Member for Central Badibu raised an issue. Even if you are amending 2, any property or payment of a sum, because payment is critical there. We cannot do away without payment. Payment of the sum so forfeited. We need to maintain that.
Any property or payment of a sum
so forfeited.
So, you know, that's so I asked, and they said it's not be there. But I think it's relevant.
It's very, very important.
Because it is, pardon? So forfeited. Any property or payment of a sum. Are you following? A sum so forfeited by an order of the court shall be dealt with in such a manner as the minister may direct. Yes?
Now, what about any property? Because you say any property or payment of a sum. You are talking to us about payment of a sum. Then what of the any property you stand? What about that? Why are you telling us any property now? You said any property or payment of a sum. It's very clear that you are talking to us about the payment of a sum. Then what about any property that you have at the later? What about that?
Property or sum so forfeited to the state. So forfeited. It says any property, where is it? Any property or payment of a sum so forfeited by an order of a court. You know, it can be a sum of money, it can be a property forfeited by a court order. Yes?
You know, you asked one question earlier on when we were looking at something else. You asked very critical question, why the need? I want to ask the committee, why the need even to change section clause 37? What is wrong with it? Because I'm now asking myself, what is wrong here that we are even trying to fix? Please, can you tell me clause 37 as drafted? What is wrong there that we are trying to fix?
You want to ask? No, wait. He's asking. You know, we were there with your experts, and they agree with these suggestions. These suggestions, because they are not addressing the same problem. You see, for example, the 2 you are talking about. You know, we are not talking about payment now. We are talking about forfeiture. So if something it's a sum that I found in your account, and the court is forfeiting it. It's a property that the court is forfeiting. So it's not about payment now. It's about forfeiture. That's my understanding.
No. You are then that's why I'm asking this key question. What are we trying to fix? Let's look at clause 30. Let's treat it together as a whole and see.
Okay.
1. It says if a person is convicted of an offense under any of the following sections, namely section 79, 80, 81, 95, 96, and 97, some of which are relating to bribery, corruption, and things like that. The court may, in addition to or in lieu of any penalty which may be imposed, A, order the forfeiture to the state of any property which has passed in connection with the commission of the offense, and any property or sum so forfeited shall be dealt with in such a manner as the minister may direct. That's A, forfeiture. Forfeiture only happens when property is seen and is identified and it is there. B says, if the property cannot be forfeited or cannot be found, order such sum to be paid as the court shall assess as the value of the property. So where now the proceed of crime cannot be forfeited or cannot be found, the court can value that proceed, whatever that article was, and then attach a value to it and ask you to pay that. Here is payment, it's not forfeiture.
And two also, read two.
All right? If the article, the proceed of crime is an article that is seen, can be identified, can be found, it's going to order for it to be forfeited. So the court, the state will use its authority to just go and forfeit it. But if it is something that cannot be forfeited or cannot be seen, it's not found, it's not known where it is, then the court will, okay, look, this is the value of the thing, pay it. And in that regard, it's the payment that is said that the minister have to regulate. So, and that is what 2 is doing. 2 is addressing B only. 2 is addressing B. B is saying where you cannot forfeit because you cannot find it. Then the court is imposing monetary, sort of like a fine. It's more or less like a fine. If we have seen the article, we were going to take the article away from you. Now we cannot find it. The court values that article and you say you pay it and refund it. So paragraph 2 is addressing B. Only B. It's not dealing with anything else, only B.
Minister, in 2, the payment of a sum so forfeited shall be dealt with in such manner as the minister may direct. I mean, the payment of a sum so ordered, then, instead of forfeited. Because it now is from your explanation, it means the court has to give the order to.
So order to be forfeited? Yes, yeah. The forfeited must be there. Order to be because you know if the court that is forfeiting, so it's not the minister.
Yeah.
So they have to withdraw the amendments.
Yeah, but what you, in this case, Honorable Speaker, what you are being asked to pay is deemed to be not belonging to you. So it's a form of a forfeiture. It's not a fine. If it is ordinary fine, that's it. But you are now asked to, it's like you benefited. And they say you benefited illegally. So therefore, we are forfeiting that benefit from you. So refund it. Pay, yes. So the payment here in this particular sense is a forfeiture of something that accrued to you wrongly and is being now taken away from you.
Just hold on. Honorable Minister, can you correlate the 2 and 3? Number 2 and 3.
3 is enforcement.
Yeah.
Where there is default, it can be enforced as a court fine.
Yeah, the payment of a sum so ordered.
Yes.
To be forfeited.
Yes.
That one is correct. But the other one is payment of a sum.
So
It's
ordered.
so ordered.
Yeah, we can take it. You know when
You know, because this one, then it becomes almost the same language.
Yeah. We can take it. So ordered. So ordered to be forfeited. So ordered is the same. We can take that, so that it's consistent.
Only. No, what he is saying is there is in fact no need for amendment. Your amendment proposes what is already there. So rather than just leave it as it is.
No.
That's the argument.
No, Honorable Minister.
Yes.
2. You know, if you look at B, it is saying if you cannot find the property that should be forfeited, you change it into money terms. And it is that money, that sum that is forfeited, that sum shall be dealt with. You know, that's how it is going. It is that sum, not the payment. But there is no payment that was done. That's why we wanted to eliminate the payment issue and say just the sum.
But you are asked to pay.
You know, but you know you did not pay.
It's a property that probably should have been forfeited. Now, in the absence, you are asked to pay. Am I right?
Honorable Chair, you have this table. They are looking for this table. They cannot see this table. So they turn this table into money and say the value of this table now is 5,000.
Yes.
And they are saying that 5,000.
Yes.
So is what they are going to forfeit. That 5,000 is what they are going to say. When they say
where is the 5,000 coming from? Where is the 5,000 coming from? Yeah, who is paying? Where is the money coming from? It's coming from him. He is to pay that amount.
Okay, with your permission, Honorable Speaker, I see your point on behalf of your committee that you are speaking for. We look at the verb here, deal. That is the dealt there. Shall be dealt with. So your question is, what are we dealing with here? What is the minister going to deal with? You know, dealt is the past participle of deal here. What is the minister, sorry, excuse me. What is the minister going to deal with here? Is it the payment or the sum? That's the critical question you're asking. It is the sum. I tend to agree with you now. So the sum so ordered shall be dealt with in such a manner as the minister may direct.
What is the minister going to do with that? Because I was going to believe that the minister may come in at a mode of payment type. But the sum ordered, what is the minister going to do?
Well, that's a...
Honorable Chair.
Because, Honorable Speaker
Honorable Minister,
is asking, because the point is, I was thinking of this also. If it is forfeited and other money is ordered to be paid, if it is paid, it goes to the consolidated fund. It's not for the minister to deal with that money. Sorry? So I think what we intend the minister to deal with is the payment, not the sum. Because once payment is done, it goes straight to consolidated fund. It's no longer the discretion of the minister to deal with that money. Yes.
And then the court is now asking, you go to the minister, who will tell you how that 10 million is going to be
so
paid.
I think it's the payment that he deals
and that
with,
will
not
be
the sum.
probably first quarter, this amount, this you agree, and then you go.
The Minister of Justice doesn't have a discretion over public
over money?
No. So what he is to deal with is the payment. So this drafting is still correct. Maybe we just change forfeit to order.
Yes, that's forfeit.
So the payment of the sum so ordered shall be dealt with in such a manner as the minister may direct. It's the payment the minister will deal with, not the money.
Do you follow? Are we on the same wavelength now? You see the beauty of... So the only amendment on 37 forfeiture is everything is left alone except forfeited in paragraph 2. Forfeited is changed to so ordered. That's the only amendment. It is proposed that clause 37 forfeiture stand part of the bill as amended. Yes, there are amendments. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 38, general punishment for misdemeanors.
It is proposed that clause 38, general punishment for misdemeanors, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 39, treason.
It is proposed that clause 39, treason, stand part of the bill. You have proposed amendments? Yes.
Yes, clause 39, Honorable Speaker, we say clause 39, subclause 1D. Subclause 1D, second line. There is the word there, lawfully, to subject any part of the Gambia to attack by land, sea, or air. So that lawfully, we want to change it to unlawfully. Incites or assists or procures a person to invade the Gambia with the armed forces, or unlawfully to subject. Because if you are doing that, we think that it is you are doing an unlawful thing, not a lawful thing. That's our understanding. Cody? It should be unlawful. That's what I think.
To agree with you, Honorable Minister.
Assist or procures.
Have you seen it?
Yes, I have seen 39D. That's what is being referred to, isn't it? 39(1)D. A person who incites or assists.
Let's have both words, lawfully or unlawfully.
Any part of the Gambia to attack lawfully. No. To attack by land, sea, or air, or assist in the preparation. That's another thing again. Or assist in the preparation. So what we are saying, this particular one is unlawfully to subject any part of the Gambia to attack.
What is lawfully here? What do you mean by lawfully here? We need to interrogate that first. Let's interrogate the lawfully here.
A person who incites,
yes,
or assists, or procures a person to invade the Gambia with an armed force, or lawfully to subject any part of the Gambia to attack by land, sea, or air, lawfully. That cannot be cried.
Honorable Speaker, I right as I am thinking on this, I'm looking at it. I would have just even deleted just the word lawfully. Because I don't think even unlawfully you can either way. If it says a person who incites or assists or procures a person to invade the Gambia with armed force, or to subject any part of the Gambia to attack by land, sea, or air,
fine,
or assist in the preparation of any such invasion or attack, commits an offense.
That's fine.
Yes.
So you don't need lawful or unlawful there.
But if there is to be a word, it cannot be lawful.
It cannot be lawful, yes. But I think we just remove it completely.
We just remove it.
Yeah. Anybody who assists anybody to attack the Gambia. Yes. We don't care
Or,
whether it was lawful
or to subject any part. Yeah. Is that the only one, Honorable? Is that the only one? On that paragraph, on that clause? Mike?
39 subclause 1F. 1F line 4, where you have coerced any other citizen of the Gambia into opposing the government or otherwise into withdrawing or withholding his or her support from the government. So that we want to change it to replace it with overthrow the government.
instead of if you do any of these things, withdrawing or withholding your support. Because no, there is no overthrow there.
Yeah, F.
We are saying
A person who causes or attempts to cause the death of a member of the government or other citizen of the Gambia with a view to securing the overthrow of the government or with intent to coerce any other citizen of the Gambia into opposing the government or otherwise into withdrawing or withholding his or her support from the government.
Yes. So you see that
The amendment is not relevant there. Their amendment is not relevant. There is already overthrow of government.
You know, my only problem is coercing any other citizen of the Gambia into opposing the government or otherwise into withdrawing or withholding his or her support from government. People can support or not support. So what is the meaning here? The cause is the cause. So forcefully do it. Is it force? Cause doesn't mean force?
Force means force.
Okay. So what do you want to? What do you want to? Why do you? Why overthrow is already stated. Honorable Willis.
Opinion was thinking that for example, the opposition, they are free to support or not to support. That should not constitute, wanting to overthrow a government.
Yes,
they want to be
I agree with you, but it's the word coerce that is used to qualify it. Yeah, this is what I'm saying. You know, I also argued similarly that people have a right to support or not to support. But people don't have a right to force people not to support a government also. Yeah. That is removal of lawfully in paragraph 1D. It is proposed that clause 39, treason, stand part of the bill as amended. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Let me tell them so that let it go on record.
Honorable members, 39(1). It has no 2, therefore that one is out. That one just remove it. 39. If you say 1, it implies that there will be 2, and we have not seen any 2. (39)(1). A person, that one is no, there is no relevant. It should be removed. It's just 39.
Clause 40, concealment of treason.
It is proposed that clause 40, concealment of treason, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 41, spying.
It is on spy, on 41.
Yeah, we have clause 41. The committee proposes that the clause 41 stands part of the bill, but then the term enemy in clause 41, subclause 1A should be defined in the interpretation section. Additionally, the penalty stated under clause 41, subclause 1 should be consistent with the penalty for the offenses under section 3 of the Official State Secrets Act. We are recommending that the ministry looks into these matters.
We have to do now is the ministry can no longer look into the matter. We have to look into the matter, conclude it today, and pass it today. One.
We need a definition.
Yes, just hold on. I'm not denying. All what the committee could have done is to follow up on these things, whether it has been done. Because they are going to lead us in committee, and it's not the responsibility of the minister to come and tell us this is what should be there. He only helps us. So if you have not done that, we cannot now just tell them they are the ones who should have done this. You should have made sure this is done for you to prepare yourself for it. So what we are saying, let's have your proposals one by one. 41, what is your first one?
Definition of enemy.
The definition of enemy. Enemy in where? 1A. Okay. A person who for any purpose prejudicial to the safety or interest of the Gambia makes any document which is intended to be or may be directly or indirectly useful to an enemy. He wants us to define enemy. Enemy is the opposite of non-enemy. If you are not a friend, you are an enemy. So what my problem is, if you want to define that now, you may limit it to a level where it should have passed that level. You have to be very careful in that definition. And this is regarding spying. Let's just wait. Yes, Banjul South.
We leave it open. Anybody can be termed as an enemy.
Anybody can be termed as an enemy.
Yeah,
this is going to be in a law court. It's not for me to say that you are an enemy and therefore you become an enemy. You must prove that you are. I must prove that you are an enemy. Anyway, let's hear the Honorable Minister.
And enemy here is not personal enemy. Enemy to the state we are talking about. So you cannot have a unique definition. It will have to be context-based and the situation-based. If you go to the Armed Forces Act, the soldiers will define an enemy differently because they look at it from combat point of view. In the Armed Forces Act, it says it includes persons engaged in armed operations against the armed forces of the Gambia. So for them, once you are engaged in an operation against the army, you are an enemy. And in their training, they have a definition of an enemy. But like Honorable Speaker is saying, in our civil arrangement, somebody can also be an enemy of the country. All right? So I think to attempt to have a universal definition of an enemy will be very, very difficult. It will be context specific. But for us to go to bed and sleep, we are not talking about enemy between you and me here. The person must have done something that qualifies him to be categorized as enemy of the state.
Okay, can we specifically mention enemy of the state then? At least then.
Yes. But here, spying can only be of the state.
Yes.
He's not talking about spying on Fabakari as an individual. He's spying on Fabakari probably as an agent of state. It's not a personal issue. Spying here is not personal. It's about the Gambia and the state. A person who for any purpose prejudices to the safety or interest of the Gambia. You see, it's mentioned, categorical. Makes any document which is intended or this thing. An enemy, we all know the enemy in this case. Yes. Yes, and and you must prove it, that your document or whatever you have done is, you are definitely an enemy to the Gambia. What is the second one, Honorable?
It's the same thing. It says, I mean, we are not, also, this is not personal, this is the recommendations made at committee level. That is what we are guiding you on.
Yes, yes, you are right. You are just doing it on behalf of the committee. Yes, please go ahead. What is the second one?
The second one says penalties stated under clause 41, subclause 1 should be consistent with the penalty for the offense under the section 3 of the Official State Secrets Act.
All right, commits an offense and is liable on conviction to imprisonment for 15 years. Is that what you are talking about? Yes, that's fine. Now, to imprisonment for 15 years, that language means legal people. Imprisonment for 15 years, it means it can only be 15 years. Am I right? The judge has no discretion, 14 years, 13 years, 17 years, no, 15 years.
What we are saying, is it consistent?
I'm coming to yours. I'm talking to the legal people. Huh?
But they're saying it's consistent, the Official Secret Act.
No. Question is, where is it? Commits an offense and is liable on conviction to the imprisonment for 15 years. That means the judge has no other discretion. Immediately you are convicted 15 years. No, not more, not less. Is that the meaning? That is, for me, that's the meaning I understand from you. And you don't think it should have discretion? It should flow, because the level of the crime. I agree. It can be even 20. I am saying that there are degrees. The crime you can have, spying is one of the worst crimes to a state. So I'm coming. Why don't it flow from this to this? Even the simplest act of being found wanting is the same as the highest level of spying level.
There is 30 maximum life. Minimum 30 years, maximum life in jail. Yeah. I agree, because it's very serious.
Chair.
Because he's telling me if you commits an offense and is liable, where liable is used, it means it can be less. That I don't agree. That word liable alone cannot make it look that way. You know, it can be liable means you are subject to that punishment, and that punishment is 15 years. So if it is 15 or not more, less than 15 or not more than 15, you can go down on there, or 15 or life to do this thing. But if we say here to 15, it means you the judge. Yes, whatever, we have to give the discretion. If it is very serious, you are now giving the judge to go for 20. Yeah, so that's what I'm saying. But you just say 15, all spying these things 15 years.
Yeah, okay. Not less than.
Are you?
No, Chair, no.
Yes, please.
Now, I think the committee is recommending that they should harmonize it with the state secret law, because the states said that 30 and life. So let's use the same thing. The state secret punishment is saying that, the state secret service, I mean, how do you call it again? The act, the state secret act. is saying that, no, Speaker, I am saying the committee is recommending the punishment because in their own view is less. Now they want to commensurate it now with the Official State Secret Act, which punishment there is 30 years minimum and life. This is a serious thing.
Pardon?
With the State Secret Act.
No, Honorable.
Intelligence.
What he's saying, in short, is that this secret giving information, secret
fine.
information,
It's serious.
Is of a lesser nature than spying, the using of the word spying. So why should spying be less punishment than that Official Secret Act?
People go exile on spying.
If somebody is convicted for that with a minimum of 30 years, spying also they are saying should not be less than 30 years. Yeah, that's what they are saying. All right, how do we quote it? How? No, what? No, commits an offense and is liable on conviction to imprisonment for not less than 30 years. Or what is there in the Official Secret Act?
It says to imprisonment for a minimum term of 30 years and a maximum term of life.
Yeah, so that's what you want us to insert. Commits an offense and is liable on conviction to?
For not less than 30 years.
Imprisonment for a term of for a minimum, sorry. To imprisonment for a minimum term of.
To imprisonment for?
Minimum term of.
A minimum
term of 30 years and a maximum of life. So the court can decide in between.
30 years.
And a maximum of life.
And maximum of life, just life?
Yes.
Or life imprisonment? Yes. Just life. Life, full stop.
Yeah.
So the 50, let me read. Commits an offense and is liable on conviction to imprisonment for a minimum term of 30 years and maximum of life. Life. Commits an offense on conviction to imprisonment. So we have got that. And then what is the next one? That's what. So now the only we've now agreed on this amendment, on the punishment. But for the enemy and other things, it is clear. It is proposed that clause 41, spying, stand part of the bill as amended. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 42, corroboration.
It is proposed that clause 42, corroboration, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 43, consent of the Attorney General required for prosecution under sections 39, 40,
Clause
and 41.
40?
43.
Okay. It is proposed that clause 43, consent of the Attorney General required for prosecutions under sections 39, 40, and 41, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 44, inciting to mutiny.
It is proposed that clause 44, incite, you have something? Yes, please.
We have issued there 44. Honorable Chair, 44A. 44A. We are saying the caption where you say inciting to mutiny.
be proposing that we remove the word "to" in between the two to read inciting mutiny.
Huh? Reference to 44A, and then you went up to 44 again.
Okay, we just go to 44 itself, which is removing the "to."
The heading?
Yes, the heading, removing the "to" in between the two words. To read inciting mutiny, to read as the caption. And then...
Just hold on,
Yeah,
legal
okay.
people. Inciting to mutiny, and now they are suggesting inciting mutiny.
Yeah.
All right, can you go to the second one while they are thinking about it?
Yeah, the second one
The
is
drafters, Honorable Speaker, the drafters have made a point. They said titles are not specifically part of the law anyway. So it's just to guide readers and pointers. So if that is the case, it's okay. It wouldn't change anything.
What is okay?
So
Okay.
it's okay. We have no problem. We are not objecting to your proposed amendment
okay.
of removing two.
Yeah, okay. Well, it's your lawyers who advise us that. So,
All right. All right. What is the second one?
The second one is A, 44A, where you have seduce, where the word seduce is. We want to change that with incite. That's the advice we have. Instead of seduce any person, we say incite any person serving in the armed forces.
Something. Monetary aspects, a lot of things. Why do you want to change it to just... That means you may be part of it. Seduce is you can remote control and cause something to happen.
No, what the chairman is saying, they are saying seducing from the side of women. You know, that is seduce for attraction of, you know.
Is that also the human rights aspect?
Is appropriate here. It's incitement. That's what we are talking about.
It may not only mean it applies the only word appropriate. Inducement, for me, is to seduce something is a stronger, because it involves a lot of ways.
And the fact that there are two different words.
They are different.
But Chair, the word, if you look at the caption, what is there is incite, not seduce. So we want to maintain that same word. Because that's what they want to, that's what they want.
Probably more convincing. I think that may be more convincing.
But the seduction, Honorable Speaker, is not used there by mistake. I'm trying to look at the legal definition of seduce. You have different definitions. That seduction legally could also mean to lead astray, usually by persuasion or, to persuade to disobedience and disloyalty. To persuade to disobedience and disloyalty. So, which could mean seduction. It has other meanings, like all the other meanings you're talking about. There are different levels of meaning, including to carry out a physical or seduction or entice sexually, whatever. All those meanings are there, but one strong meaning that stood out, which is the number one meaning from the legal dictionary I'm looking at, is to persuade to disobedience or disloyalty.
No.
Yeah? So, it's not a load that we are carrying on our head, so we can leave it there. It will, I mean,
The other clause is also inside, is there?
Inside is there, so
But
we
this
leave.
draft has to be not just.
So they don't want anybody to escape. So we leave.
Chair,
Let me.
Chair.
Let me look at this.
44A, that is seduce. 44B, that is inside. 44C, that is inside. So it's okay as it is there.
The dictionary said it can mean.
Honorable Chair, is that for this mutiny, you're talking about only one thing, life imprisonment. Somebody is fine, he created a lot of havoc, secret acts and all these things, but for mutiny or whatever definition you give it, you say it's life imprisonment. No option. Are you comfortable with that? This is what I'm saying. It might be an oversight, but we are now looking at it. Your recommendation is noted, but we are saying now, is that still the offense? The punishment is life imprisonment.
Life imprisonment.
No option. No option.
No. It should be 30 years also. Minimum, not less than 30 years or life.
Honorable Minister. The punishment for this crime, this incitement, mutiny, is just life imprisonment. No option. We thought it could be, depending on the severity of the mutiny, it could be up to life imprisonment.
This is
Section 44. Mm-hmm.
You are inciting armed forces. This is almost this is treason. This is the same as treason. It's not inciting a civilian. You are inciting people in the service.
He said, seduce any person serving in the armed forces,
yes,
or any member of the police force from his or her duty, and that's one. B is incite any such person. Okay, any such person.
That's referring to A.
Yes. Okay. But then it means you said it's the same as treason.
Treason.
Yes.
So what do you want us to use? Persuade?
Because, you know, politicians can be trigger happy and then they will say, let's remove the government, let's do this thing. Then you go and charge them for sedition. You lawyers, that's... But sedition, it's incitement to sedition. I'm saying that's the only word I'm not so comfortable.
About mutiny. Yeah. Yes, and the police. So, can we make a proposal? It is, yes.
It's okay as it is drafted, because look at the severity of it. Yes.
I think to orchestrate a mutiny also has stages. So I think, like, jumping to the conclusion of life imprisonment will be something else. So, like the majority was saying, there could be a lower slip to life imprisonment, so that how organized it is. The sentence will determine how organized and advanced the stage of orchestrating or inciting mutiny is.
I think they may be punishing the intent. Whatever level, if your intent is to cause that and you are unfortunate, you are trapped early, you are as good as somebody who went to the last team. What would they define? Yeah, this is what I'm saying. The intent is what is being determined here. You've started. And early, when by the time you put up your things together to go about it, you are caught. Yeah, your planning level is low. When this one is advanced, you all have the same intent. The same intent.
Yes.
The same intent, yes, intent. Even God punishes you because of your intent.
Yes, but
You know, overthrowing or an attempt to create these things can put a lot of lives at risk. So if you don't have the necessary punishment to make people to deter from it, to prevent to go away from it, it can cause a lot of havoc.
in certain cases, even 30 years will be enough punishment. Even 40 years will be enough punishment.
It's true. That is true, yes.
What I'm saying is trying to make reference that I'm proposing 30 years, but that position has been withdrawn for the fact that this is very serious. And we have to make sure that the punishment or reprimanding clause here should be seen very severe. So I think we are all in agreement to maintain like that. And then that it is by no mistake that they put life imprisonment there because of the severity of it. So
qualifying thing is
yes.
you are trying to incite people with guns.
Exactly.
Armed people. It's not if you are civilians, we will understand a little bit. But this one you are telling people, you are inciting people with guns. That is going to be very bad. Because I'm not giving him the floor. Just like you were talking there, nobody was bothered. So don't bother yourself when he's talking without mic. He's not saying it for you. Honorable Minister, you better stop talking low. People are very much interested in what you are saying. Honorable, it looks like even if you put your head down, people want to know what you are saying. And when they put their head down, you are not interested to know what they are saying. So we have now agreed on 44, isn't it? You know, myself, yes, because you see, pardon? Yes?
Of Africa came here, from peacekeeping, and because of unpaid, they decided to rise up to demonstrate, and then suppose those kind of incidents happen. Not necessarily they took arms for overthrow, but that also is a kind of mutinous act. It's not acceptable with people with arms, but it was their intent. That's what I'm saying. I'm looking at scenarios where some of these things happen. Then the judge can determine whether it's life imprisonment, whether it's 50, whether it's 40. That's what I'm saying. I'm not saying remove life imprisonment, but leave it there, but still put 40 above or 35 above, and it goes to be, the court now will determine based on the evidence adduced that it warrants life imprisonment. Why should we just conclude it, even sometimes with some... Sometimes the system, the evidence might not even lead up to life imprisonment, but there is sufficient evidence to give the person 40 or 50 based on how organized, how many people are involved for some.
Yes? Yes, we will list.
No, I'm thinking that, when we say inciting, still we are at the stage of inciting. So when do we actually reach mutiny itself?
Yes, you know, I'm inciting you to mutiny, but when do you reach the actual stage of mutiny? Because usually when you succeed in mutiny, then you
when you succeed
in mutiny, then you cannot
Chair.
be punished.
Chair, must you succeed in mutiny before you punish the person? Must you succeed in mutiny before you get punished? Once you carry, I'm coming to once you carry out the intent itself, it's to be punishable. But, no, you shouldn't be asking that.
No. What I'm saying, you know, I'm inciting you to mutiny, that is one, and you have actually done mutiny. These are two different things, and that's what he is raising.
they are just like the Mandinga global babula.
I mean,
it's not you are inciting somebody to do the end result. That's your purpose, to get that end result.
No, you know,
unfortunate, you were caught.
No, I can induce this man to go and steal. Huh? That is a crime. But if he actually goes and did the crime, but they are not at the same category.
They are different.
Yes, Chairman, I think what Honorable Baji was trying to explain, like for example, soldiers coming from peacekeeping, like going out in the street showing their dismay and disappointment to the government simply because they are not paid when they return from peacekeeping. Actually, you cannot classify that as a mutiny. Mutiny, the intention should be there, whether it's premeditated mutiny or whether the mutiny itself. Mutiny, in any part of the world, wherever you go, the prison sentence is life in jail. So that's my take as far as this issue is concerned. I think we should move forward. We forget about the issue.
That is mutiny. You go on a peacekeeping, you come, you take your guns and everything, you are armed and you're going against and you are asking for something by force. It's mutiny. It's mutiny. It can lead to anything. It can lead to anything. Yes?
No, I think...
No, I didn't mention that. What I'm saying, like, if soldiers should go out in the street, coming from peacekeeping, showing their, disappointment, without using gun, you cannot classify that as a mutiny. I am not saying it's right. That demonstration is wrong. I know, you cannot say that is mutiny. That is no mutiny.
Now, yes, we heard from both sides. Yes, can we hear some other?
Yes, I'm saying, I think the different arguments are already captured here. What they are saying, for example, if you look at 45, it's saying person who incites a member of the armed forces or the police force to sedition or to disobedience to any lawful order by the superior officer commits an offense. Then if you go to 46, inducing members of the armed forces or policemen to desert, that is also there. So I think these two things are captured. It's different from the mutiny part. Yes, so we should not...
Even in the current criminal code is still life imprisonment. So it is proposed that clause 44, inciting to mutiny, which should now read inciting mutiny, stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 45, inciting to sedition or to disobedience of lawful order.
It is proposed that clause 45, inciting to sedition or to disobedience of lawful order, stand part of the bill. Those in favor, please say aye. Pardon?
Yes, the committee proposed that 45 stand part of the bill with the following amendment. One, that the clause be further redrafted as a person who incites a member of the Gambia Armed Forces or the Gambia Police Force to A, sedition, or B, disobedience to any lawful order by a superior officer, commits an offense and is liable on conviction to imprisonment of 5 years. So I take you to the second one too.
What is the difference? You just broke it down. He's carrying the same thing. Am I right? I said, I think what you've just done is, it does not change anything. You just broke it down into apartments, A and B. Go ahead.
That is the changes. The committee just break it into 1 and 2.
It's the breakdown. It's breaking it down.
Unless if the minister is not comfortable with that, like the other one, we break it down. What is your take, AG?
As it is a person who incites a member of the armed forces or the police force to sedition or to disobedience to any lawful order by a senior officer, commits an offense and is liable on conviction to imprisonment for 5 years. I mean, this is just one. Why do we need to break it down? Anyway, legal people.
Really is cosmetic. It's not changing anything. And we can save space by just maintaining one paragraph instead of breaking down into so many paragraphs. Okay.
Pardon?
Also have two, that the punishment in the Gambia Armed Forces Act should be considered for consistency purpose.
The punishment?
The punishment. You know, this one is saying 5 years.
Yes.
Whereas that other one is saying life imprisonment.
No, they are different. This one says a person who incites a member of the armed forces or police force to sedition or to disobedience of lawful order. These are different.
I think if I can remember the agreement very well, is that they remind us that there is an Armed Forces Act also. So we should consider that for consistency.
There is an Armed Forces Act. So what is in that one they are saying?
Yeah, but Honorable Speaker, from what I can see here, under the Armed Forces Act, disobedience to lawful order it carries a 5-year jail term. Yes, it's consistent.
To be honest. It is proposed that clause 45, inciting to sedition or to disobedience of lawful order, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 46, inducing members of the armed forces or policemen to desert.
It is proposed that clause 46 induce.
Yes.
Yes. Yes.
Yeah, Honorable. We are still saying let it commensurate with what is in the Armed Forces Act. So maybe you can help us again to check whether that is what is in the Armed Forces Act, the penalty.
But you people also should have checked whether it is not.
We don't have the Armed Forces Act.
You should have got it. You should have just asked for it.
We were working with the Ministry of Justice.
We are not denying.
And they have all the
You
documents.
cannot make reference to, it should be like that one, where you don't know what is there. You should have done that. Yes?
Yeah, in the
Honorable Chair, this retreat, this is government bill and the minister's bill, and they were there. We are not lawyers. When we make such comments, they are present. What happens? They should take care of it.
Yes.
What else? What demand else? What kind of demand else do you want us to make when they are present already?
Honorable, whose responsibility is it to make the law?
That's why we have them there.
That's why you must follow up to make sure it is done. If it is not done, we are not going to tell them. We are going to tell you, the committee who represents us.
Honorable, when we agree here, when we agree here that that's what should be there, then there's a time when they should put it there.
understand.
We are proposing
the
that
whole,
this
the
happen.
whole assembly. You see, now, you are the few who are leading us.
Yes.
You are leading us.
So we are
Why?
proposing.
You should have led us the same way to make sure that those things are done before today.
No. That's not how it is done. It is the way it is done is that we made the proposal. If it is accepted by the House, then they will do it.
Who will do
it?
it?
Done.
Who will do it?
The Ministry of Justice.
I think the appropriate thing is that the House entrusted you guys to go and work on this. So now, once you now consult expert opinion or expert to come and help you, these amendments that you are referring for, the State Secrets Act, the state, this thing, this thing, you should have gotten all these things now as part of your report, rather than asking them to provide one, you know.
Agree more with you. You see, Honorable, committees are to be responsible of their various recommendations and its implementation, and the report to Parliament. We have not finalized on these things. The law, why we gave you the bill, is for you people to make your recommendations and lead us through to the end of the bill. So if you people have gone on your retreat, you have your expert opinions, etc., references to things that you yourself have not seen. I mean, that looks funny.
No, let's move.
Yeah. Because you should know. All right, honorable members. You are asking about, it talks about the person, where is it? A person who by any means whatsoever directs or directly or indirectly procures or persuades or attempts to procure or persuade any member of the armed forces or the police force to discharge, commits an offense, and is liable on conviction to imprisonment for 2 years. You are talking about the Police Act or the Armed Forces Act? Because the police, do they have their own?
Yeah, they have. They are required to.
But you are talking about two. What about the police? This one. But what we are saying is, I think it also captures the police. So what about the police own? This is what I'm saying. So what they are saying is the 2 years should just be picked up from the Armed Forces or the Police Act. That's what you are saying.
Armed forces with the police. Maybe we should separate them.
But remember, armed forces means police and these things. It was told to, we are told here, security forces. That would be security force.
Chair.
Just hold on, just one by one.
So I think we are wasting too much of time.
Honorable, please. Let's get clear. If you are wasting, wait until people are ready, then you come up and bring all this thing. Yeah, you, Woolly East, you are saying they mixed up what?
Armed forces and police, they put the two together.
Yes.
So I'm saying maybe what we need to do is, if we don't want to give them the same penalty, then we have to differentiate the two by separating police from the army. You understand what I'm saying?
Yeah, I understand you. You know, when you make reference to the act, if they have two different acts, the police and the army, if they have two different acts, and then the punishment for each of those things from the different acts also is different, then it becomes a problem.
Yeah.
But if the punishment is the same, using one act to cover it up may not be difficult. Somebody was saying that somebody was talking before. Who?
What the provision here is talking about, any person, it's not only confining it to the military. The military, they have their act that is to deal with their personnel. But this is talking of any person. So I think this is apt. We should spare our time and move on. You put it to us. Thank you very much, Chair.
It's any person, yes, but if you go to do it to a military or a police officer, not to any other person. any person who does it to a military officer or a police officer to desert. That's what it is saying. So it's not about any person to any other person. It still deals with those two specific people, groups of people. Yes, please.
Yes, my submission to this is, I think the section is clear. It says introducing members of the armed forces, inducing members of the armed forces or the police to desert. I think what we could have seen a progressing thing is the committee by now could have, one, you're talking of two things here. The Police Act, it should be clear to the committee what does the Police Act entails in this. Second, the Army, what does it entail? Then from there we'll have a uniform whereby we will now say based on X, Y, Z, then we are now choosing this. So here, both the Army is unknown to the committee and the Police Act also is unknown. So I think the issue now is how do we work on this? I think this would be the focus point of what we want to move onto this. So the committee, I think the committee has now failed in this regard. The committee has, can I land please? Can I land? What I do is say so. It happens for us in PEG, Chair, where we've seen working on SOEs. What we did was we tasked the relevant ministry in which they should provide us sections or pointing laws that will entail and help us. So if those two acts were available, by now we could have seen a progressive in which we said, okay, in this point X, Y, Z, we will use this to at least, use the two things. So neither the police nor the army is unknown. So I think let's make progress in what do we want? What do we want in this? I think that's my submission.
Chair, we are simply saying if you accept our recommendation that when you do this to a police officer, we look at the Police Act, the punishment there, we put it under the police. When you do it to an armed force, the punishment there, we put it under the armed forces. So just agree with that, then the ministry will go and do precisely that. That's how you do it. No, you can separate them.
Chair. No, but let's read it here and try to understand what this provision. This is talking.
You can't say that you leave the law for the minister to edit. You are doing constitutional stage here. You must bring the facts here.
The minister's bill, not my bill. It's one who introduced it.
You are the lawmaker here.
This one is to decide.
Yes, the second provision says persuade or procures any.
I don't know why the majority and the speaker on defense. This is a bill before the parliament committed to a committee, and the ministry, together with us and other stakeholders, went and looked over these things, and we made some recommendations. And each of us have it, so they have a part to play. You want us to follow them as policemen? We can't do that.
Honorable members, we are looking at the Armed Forces Act, and it is saying, well, a person, honorable members, especially women, subject to this act, who on active service or when under orders, A, deserts, B, persuades or procures any person subject to this act to desert, commits an offense, and on conviction thereof is liable to imprisonment for life or any less punishment provided by this act. Yes, please.
Let me help to clarify something. The Armed Forces Act that you just read deals with serving soldiers who commit the crime. And like the member for Serekunda was saying, the soldiers have their legislation to deal with their offenders. They don't use the criminal code. So if a serving offender either deserts or persuades his or her colleagues to desert, that is the punishment for him under court martial. That's only applicable to soldiers because they use their own code. The Police Act also talks about a police officer that participates in a discussion or meeting, what will apply to you? This criminal code is for the rest of society. It's not for them.
Yeah, but you are doing it to the army.
Yes, yes.
And the police.
Yes.
You are inciting them to desert.
Yes.
For the army, when they do it themselves to each other, it's life or a lesser prison. Yes. Yes. And this one now is 2 years.
It's on the low side. We should also raise it to 30 years, not less than 30 years.
How can you now sentence somebody to, huh? No, what I mean is, for somebody to serve in the army, the maximum is 12 years.
We are not saying army service now. We are saying that someone now, a civilian.
Don't allow me land.
Okay.
His service, soldier service to the country, the highest you can sign is 12 years. Now, if somebody incite that person to desert, you think the punishment should now be 30 years, exceeding this amount he's supposed to serve twice?
Either way, I think I have a duty to make you appreciate the seriousness of these offenses, particularly for the armed forces. Desertion is a very serious offense in the armed forces, especially sometimes depends on the timing. A soldier deserting in the middle of an operation exposes the rest of the soldiers to risk. You can be asked to guard a particular position, and you leave your guns there, or you decide you go with your guns. Because that duty position is left unattended, you have exposed the rest of all your colleagues to danger. If attacks should come through that point that you have deserted, you almost risk, a lot of people being killed because you alone have left your duty station. So it's not trivial. It's very, very serious offense to desert, because if you are under an order to go and do something or perform certain operation, if you abandon your duty, you expose the rest of the military to a lot of danger, because they rely on you being there and you are not there.
Honorable Minister, and equally, if a civilian comes to convince you to desert, you are causing the same liability to these things.
AG, what you just describing is not desertion. Desertion doesn't necessarily mean leaving your guard post or leaving, desertion is leaving the army itself, running away. It's different from what you explained. Like,
Honorable, I said depending on the time of your desertion. You can desert in the middle of an operation. You can leave your duty position and desert and leave. It's all desertion. Listen to the way the armed forces are described. Let me read the armed forces act.
No. What he's saying is, you are saying desertion means leaving the army.
Run away from the
You can run away from the army when it was difficult.
That's what I'm saying. I agree with that.
Yeah, that's what he's saying. He's saying at the time of operations, you are at a guard post, something is coming, you decide to leave the army by abandoning. It's as dangerous. And two, my argument is, for the army and for the civilian, Emmanuel Dambake. Because you are causing the same harm. I think 2 years is too small. It can be five. Yes, please. Woolley.
Chair, I don't know how we're going to, what the minister explained? I say what the minister explained is, he's saying this is a civilian who is trying to persuade either the army or the police to decide. But how do we know? Because he's not saying that. This is just saying a person.
Yes, a person means means person. A person can be a civilian, it can be a non-military officer, it can be a military officer.
Yes, and the punishment is meant for that person.
Yes,
it's not meant for the one who
this is why he's saying that the punishment should not be the same as if it is with a military man to a military man. That's what he's saying.
Yes.
Now, but what the other argument is, the person also, if he is a civilian, is equally a bad person. And the 2 years is small. If it can be 5 years, for him to do it. If the other one is life, he should be able to get 5 years for inciting people to desert, soldiers to desert.
I'm saying, I would suggest, for example, in 45, the 5 years that is there, we give the same 5 years in 46.
All right, honorable members, look at 46. Imprisonment, conviction to imprisonment for, is it for not more than 5 years or not less, but just for 5 years?
For 5 years.
You know, this for these specific these things, I don't like that language.
Let's say not less than 5 years. I mean, not more than 5 years.
Yes.
Not more than 5.
Can we? Yeah.
Chair, I think it is apt here. So we also have to be very reasonable here. Do we have the capacity to keep all those that are expected to commit crimes in those facilities? You know, drafters don't only draft for the sake of drafting. They draft with reasons. You understand? And this is talking about civil. So I was just trying to tell the majority leader that whether we have the facilities to keep all the people we expected to commit crime. So maybe the drafters are also considering that, and what the 2 years in prison can change the life of an individual as well. I don't know.
It's commensurate with the crime. That's what we are saying. We are not advocating for heavier crime. If somebody in the army does it and is going for life imprisonment, and the repercussions and consequences can be almost the same. So just because you are a civilian, if you are not going for life, but at least you should have 5 years so that you avoid doing it. Inciting people to desert. That's the purpose.
Chair. Is it common for a civilian to...
Therefore, then nobody will suffer from it.
It's not common in our
No, if it is not common, then we are good.
Chair.
We are good then.
Chair.
Yes.
I don't think we should put this place not more than 5 years, because it becomes discretionary now to give 1 or 2 or 3. Let's maintain as it's captured for 5 years. It means they give you 5 years. But if you say not more than 5 years, how about if the person is given 2 or 1 year?
Yeah, you know, some people were suggesting not less than 5 years, but not more than 10 years. So that's some people were suggesting. Some people were suggesting not less than 3 years, not more than 5 years. So there are various thoughts. So, you know, what we try to do is to cater for the severity of the crime. You know, it cannot be everything equal. Because if you say, if merely you are convicted this time, it will all be 5 years. No options. When you look for mitigation and all these things, certain conditions before fine, all those things will not be considered. It is just 5 years, go for 5 years.
Yes, Chair, you know, we said that for an armed forces should go for life imprisonment. We didn't bring any option because of the severity of it. So it is in this same respect, we should also treat this one with a severe action that is very serious, that is go for 5 years. If we should treat...
No, there are options in the armed forces.
No.
Or any act less than that amount. Yes, it's qualified.
No. We said mutiny now, if you commit it now, you are going for life imprisonment. There is no option that says that 30 years or life. 44. Yeah, we said life because of the severity of it. So it is in the same respect, because of the severity of treason, yes. Now, somebody who is now trying to make an officer to desert his or her position during operations is equally serious as well.
During operations?
Anytime.
Honorable, my friend is a soldier, I want to go with him. I said, leave the army, let's go. All those things are possible. Inducing people to leave with no bad intent. It has a lot of these things. What we are saying now is give the magistrate a room to maneuver depending on the severity and the
okay, how about we say not less than 3 years and more than 5 years?
Yeah, I mean, that's the language we want.
Okay. Not less than 3 years and no more than 5 years.
Just one.
Thank you very much, Chair. You guys are sleeping because we have been listening to our time and they are not responding. I'm suggesting we live for 2 years.
What did he say?
Your guys are not saying. I'm suggesting that we live for 2 years because there's a reason why people are leaving the army. What is the what is pushing?
No, you serial man, you stop first. Let me change over to.
There is no serial man here.
To Kiang.
You see
Kiang West. I'm going to tapi deman.
Madam Chair, not more than.
Go ahead.
Not more than. Okay.
You guys, you see the powers vested in me by you.
So no problem. I also have somewhere to hold you. No problem.
So you don't need to make those comments if you know that.
Yes, yeah. My suggestion is we live for 2 years. Reason being is the minister was trying to make a suggestion here. Let's see it this way. I'm in the battle where I can protect or secure my men. When I'm overcome and I have the access to run away, how will I call it? I'm saving my life, I can run away and save my life. Number two also, the other thing also, why are people living? There's a reason why people are living. No, I'm coming. It's everywhere. Let's try to be flexible here. Let's leave it at 2 years because there are reasons why people are living. People don't just jump and leave.
Honorable, the essence here for us, honestly, is to prevent some of these things. They can be deadly. It can be the cause of havoc in any country. It depends. So it is important that people who want to go into it should think twice. This is not small joke like you are hungry, you took a biscuit from a shop. That one we understand. But you inciting people, you asking people to desert for various reasons. Those responsible for our own security, it's not for civilians, it's for security forces. We must not see these things in the light. We want to, if you don't do it, it has no effect. Yes?
Absolutely right. In fact, should even happen, should even encourage as a parliament that people leave army for obvious reasons. I mean, it's shy. This is a noble obligation. I mean, noble job. Students shouldn't be seen trying to justify it as it's normal for you to say you should leave because of hardship. I mean, I want your man to withdraw a statement.
No, I'm not withdrawing. This is not about trying to encourage people to leave. We are working here as parliamentarians. We live here and go to other jobs when we have opportunities. No, they are not the same thing. They're not very flexible here. They haven't been like us. They are serving this nation.
Honorable member for
they have the right to leave.
Yes.
Cannot be hard on them as we if you want to have the hard on them. I think we do that statement. It's wrong.
Joshua, what's wrong with you?
My majority is talking.
No. You don't have to.
No, but I am going. I don't say anything here.
Honorable, please. Don't take me out of my house. My friend, you behave like a human being and like a member.
I'm also being like a human being.
But you don't.
No, but I'm saying I'm a very fair order on my chair. I never say this in front of you.
Honorable, in Parliament, you go by regulations and laws. You are not there to just to shout. Otherwise, we will all be shouting and we will go home.
Chair, I'm not shouting, Chair.
No, you are shouting. Who gave
I'm
you
not
the floor?
shouting.
Who gave you the floor?
I'm not shouting, Chair.
Who gave you the floor?
You gave me the floor, Chair.
No, I never gave you the floor. I gave you the floor, you finished, I gave somebody the floor. When he talked, you shouted on him. That was not correct. I told you people, we have different beliefs. But let's respect each other for whatever we say. You can disagree. What he says, you may not be in agreement. When he is ready, say, I'm not in agreement. You bring out your own. Members will listen and they will take the best for themselves. So there is no need for us to shout and do all those things. Somebody may say something that I don't like. I will wait until you are ready. I will say something that I believe is right. But to shout at each other, it will not help us, please. And what is at stake here is, the last suggestion we had, it was in the act is 2 years, am I right? In the bill, yes. It's 2 years.
we're talking about moving it. I said some people talked about not less than 5, not more than 10, and then some not less than 3, not more than 5. And I think somebody suggested, I don't know, somebody made a suggestion, yes? 3 and 5. Yeah, not less than 3, not more than 5. Huh? Okay, we pick it from there. Yes, Honorable Member for Kiam.
Honorable Chair, not more than 5. Not more than 5. Not more than 5 could suffice. You know, I think they might give 2 or 3 or 4, but not more than 5 could suffice. Please.
The others are saying, that's your suggestion, good, but others are saying the crime is such that it's bad. So if you just leave it at not more than 5, it can be 1 day. It can be 1 month. That's what they want to avoid. They want to regulate it. That's why we do not say for 2 years and stop. We want to regulate it. So that depending on the severity, it can go range from 2 years to 3 years to 5 years.
Okay, now not less than 2 years and not more than 5.
You are not saying, you are no longer with 3 years, not less than 3. You are suggesting not less than 2.
Yes.
Okay. So, yes.
Chair, I think like you have given a scenario here, an example. Like you can be sitting with soldiers, you tell them, as Gambians, we do that, don't worry, leave the army. That's deserting. So I think we leave it at 2 years, it's okay.
Not less than 2 years. But in case it is above that, is to weaken the army and to create problems in the army. 2 years, the same thing. So that's why we have the range, the severity of your crime. So the suggestion here is 3, not less than 3, not more than 5. He is suggesting, like you, not less than 2, not more than 5. So any other person? Yes, Lower Salum.
Thank you, Honorable Chair. You know, these parliamentarians, if you allow many observations, we will not make any headway. But the majority leader said not less than 3 years, not more than 5 years. And the other make another difference. Why don't we wait for voting? We proceed, because these are minor things. Let's vote.
You observe it, Honorable Member. I don't like usually voting. You know, the more you discuss issues, the more informed people get, and therefore they come to agree. That's, you know, that's more, you bring out more information, more facts. It makes people accept. That's why we do it. Otherwise, all the time vote. You can vote on something and it is adopted, it may not be very good. That's the only reason. But it looks like these are the two. 2, less than 2, not more than 5, not less than 3, not more than 5. These are the 2. Yes, somebody's card is up. Yes?
I am suggesting we make it like not less than 3, not more than 10. That is my suggestion. Because sometimes the severity, the crime might be severe, so much so that it would not be necessary for it to be less than 10. Yes. Not more than 10, not less than 3. That's my suggestion, please.
Yes.
Yeah, I'm trying to I want us to get the facts about this desertion. What is meant by desertion in the armed forces language, and what is meant by, is it our? You know, I think desertion is a lesser thing. I think it's leaving your post of duty.
AWOL is a form of desertion.
Yes.
Desertion is the global one. So an AWOL is part of desertion.
No, is it desertion is part of AWOL or what?
It's a form of desertion. Our own is just absent without.
Yes.
It's a form of desertion.
Okay, then we are on track.
Chair.
No, speak.
Chair, I want to.
Yeah, but I want us to.
Yes, to address what is happening right now.
Yes.
Let's try to bring it down to compromise. Not less than 2 and not more than 5 could be seen reasonable. 2 and 5. Yeah, that's more reasonable. Not less than 2 and not more than 5.
Yes, Honorable Chair, I'm suggesting we leave as it is, 2 years.
We have passed that stage. We have gone and argued over and over and over the reason why just 2 years is just 2 years. For all times, we agree that we give it range. So we have passed that stage. Otherwise, we will not have been agreeing all this time. So, honorable members, you are now agreeing for it to be not less than 2 years, but not more than 5 years. Which is clause 46. Have you got that? Yes. On conviction to imprisonment for not less than 2 years and not more than 5 years. It is proposed that clause 46, inducing members of the armed forces or policemen to desert, stand part of the bill as amended. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 47, aiding prisoners of war to escape.
It is proposed that clause 47, aiding prisoners of war. You have something?
Yes.
Yes, please.
Yes, thank you. 47, Honorable Speaker, in 47(1), line 4, there is the word payroll, stated in line 4, payroll. Parole. Okay, parole. Yes. So, and that is new to our jurisprudence. So we are suggesting interpreting that in the interpretation section. It should be captured. We've just discovered it.
There is no. No, who said define?
We say it should be defined in
your report says to be defined.
Yes.
Yes.
That's our.
But what we are saying, that's what is in the report. What we are saying is, does it need definition actually? It's an ordinary word, parole.
It's a common term.
It's parole.
It's not, it has never been in our.
It has been, it's not new. Section 43 of the criminal code. The old criminal code that we are using.
Yes.
It's there.
It's there.
Yeah, it's not new.
Okay.
It has been with us all this while.
But in fact, parole itself. Parole, if you want to. All right. So you are fine, Honorable. It is proposed that clause 47.
Chairman.
Yes, please.
Can I ask a question? AG is saying is in the, you say which of the acts? AG, because I don't think it is in this particular one. The old criminal code.
The criminal code.
Whatever. Yeah. The one currently being used.
We are not entirely rewriting the entire criminal code. There are some that are new, but a lot of them are maintained. So this aiding prisoner of war to escape is under section 43 of our old criminal code that we are using. It's almost replicated, it's maintained. It's not a new thing. And the word parole is still there since this criminal code has been known to the Gambia. So it's not new.
Parole is like to pardon.
So if you have the criminal code with you, volume 3, go to section 43. You will find the same paragraph there.
Agreed, but disappointingly, your men should have told us that at the meeting. They were there. Why didn't they tell us?
No.
All right, okay, let's write over it. It is proposed that clause 47, heading prisoners of war to escape, start part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 48, interpretation of section 49 to 52.
You have something? Yes?
Chair, our recommendation in 48 is that the word sedition or seditious words should be properly interpreted or defined. And to the word sedition, 48.
Take us to the place.
Seditious words is in page 36.
Yes.
Huh? Which means
seditious publication, you mean, or seditious words? Yes.
Yes. You know, they just say means words having a seditious intention.
Yes.
So what is the meaning of sedition, Isha?
Yes.
Can I come? Please. If you look at C, seditious publication. Look at seditious publication.
Where?
Seditious
Publication.
Yes.
It says seditious publication means a publication having a seditious intent.
So what is sedition? What do you know about sedition?
I want them to interpret.
Is there any sedition in Kantora? No, we are, you know, our final distinction, Honorable Speaker, is that clause 48 to 52, in fact, we are recommending that let it be deleted.
48?
In total.
48?
48 to 52.
48, 49?
Yes. 50, 51, 52.
50, 51, and 52.
Yes. Because it's all dealing with sedition. The world has passed that stage now.
Interpretation of section 49 to 52.
Yes.
For the purpose of this thing, import includes to bring into the Gambia.
Yeah.
Periodical publication.
Yeah.
Includes every publication issued periodically.
Yeah.
Periodical publication, again.
Yeah. These are colonial laws. It is. It's terribly colonial.
Includes
these are archaic words.
written and printed matter.
Huh? What situation will warrant us?
But what do you mean? What do you mean for us to remove all these things?
From bringing intellectual properties and so on and so forth.
No, you put in something. Everything can be controlled. Anything is the way it is controlled. You cannot leave things, however good, open. It's never good. Even the right. Now, this is what I'm saying. What is not needful there is what we should remove.
No, nothing is needed there.
No, but if you tell me, for instance, import means to bring into the Gambia, that's needful for me to know the interpretation of import. And if you tell me periodical publication includes every publication issued periodically, or what? These are informations that they are necessary. Publication includes all written and printed matter. So you telling me all those are not relevant?
There's no need for these things in our statute books now. What are you trying to?
You will tell us.
These are colonial things.
I think what you will do is the bad side of each of them tell us, and then we look at it and then either agree to remove or pull. You know. For instance, in the interpretation, for the interpretation, we leave that as it is until because it goes to interpret these other words. When it's done, then you look at it.
Preventing us from importing books that will help the people to understand, their situation, etc., so that they'll be able to. Those are their concerns. Now we are not in that situation.
there is internet and there is information flow. It's like you cannot control information now as such. But we also have access to information. We have all those things. So in terms of sedition, you know, you don't need that type of law now in our books, really. That is our decision. So, but you can do whatever you want to do with it now. Yeah?
Good.
Get from.
Simple as that.
You don't need it.
Honorable, I don't think that's very progressive. You cannot just be, it's your responsibility if you want us to remove it to convince us beyond all doubts. Not only reasonable, all doubts. That's what you are saying is correct. So you must be patient to explain. Now, but you are saying you either that's it, or you leave it, or you this thing. That's not good. You cannot say that.
No.
Honorable, all right, just look at it. Honorable, if you look at 49, because this one is reference to 49 to 52, I don't know. 49 says power to, it says, where the minister on reasonable grounds considers that it is necessary in the interest of public order, health, morals, or security, and to be reasonably justifiable in a democratic society, he or she may, by order published in the Gazette, prohibit the importation of any publication. What is bad about that? Yeah, that's why are we solely allowed to make laws for the Gambian people? Pardon? All of us, I mean all of us here. Yeah, why are you the Gambian? Because you are representing them. They gave delegated power to you. So we voted for the president, and the president assigned, delegated these powers to him, to the minister for certain responsibilities. So, but what we are saying here is, all our fears, for me, all my fears are gone when I looked at it, because it says morals, security, and order, reasonably justifiable in a democratic society. The law, the courts, that's why the courts interpret these things. But if the minister feels otherwise, you go to court. This is why the courts are there. If you feel somebody has offended you and has gone wrong, take him to the court.
Minister mentioned court here, and you're saying, no, you cannot, not everybody has access to that court.
But that is the premise. That's how we operate. You know, the laws, some laws are made and people abuse it. You go to court. Yes, yes, Kiam West.
Yes, we may leave it there for the minister, because, you know, people in our jurisdiction, people can go to court with the highest authority and they win. So it is possible. It's where when we have an independent judiciary who can be very free and fair in their judgment, it is possible. So people can contest the decision of the minister, it doesn't matter. So when he makes a decision that is not in line, people can always contest that decision to the court. So I think it's fine.
I said it may be difficult for us to say 49 to 51, remove all. We deal with them, and then you make your recommendations, and we look at it. Because when I read this one, I can go forward to read the other one. So are the ones that you think we are not good, you can remove them. If the president, on reasonable grounds, considers that it is necessary in the interest of public order, health, morals, or security, that the importation of publications published by any company, institution, firm, or person of whatsoever kind, or in or emanating from any country or place, would be contrary to the public interest, he or she may, by order published in the Gazette, prohibit the importation generally of any of all of such publications.
Yeah, we have, you know, this is a new age. This is information age. Information is flowing everywhere in the internet, everywhere. So how can the minister control that?
It's not the minister. They are
How
saying
the
the president.
president is going to control that?
Chair, why do we need to pass the Information Act? It's to regulate this information, to regulate the internet, to regulate this thing. So we cannot say because information exists everywhere, could not be regulated. So this is a form of regulating this information you are getting. You can have every access to the internet, but you pass in this assembly access to information, haven't you? Haven't you passed an act?
You know, Honorable, it is true that information is everywhere, but it's not accessible by everybody. No, yeah, no. Honorable, that's not a fair statement. Therefore, it should be left open. No, materials to be imported by people for a purpose can be stopped. Honorable, let it be stopped. If you can get it through any other means, go and get it that way, but you cannot come physically under those orders. That's what it is saying. If it's not in our interest, it's not in the public interest, in public health or morality, I mean, and you are aware, you should be able to stop it. Yeah, but if you feel it is also available somewhere, you can tap it, you go and tap it, but if it is known, the punishment will be for you.
Like, you cannot bring, prawn, or prawn posters or these naked pictures importing, you have to stop it. You have to stop it.
Chairman, I think the provisions are very, very progressive, and we should just leave it as it is. Whatever is contrary to the public interest should not be allowed to come. And to say information is everywhere, I think that is vague. It must have a source. It must have a source altogether. So I strongly believe the committee's proposal does not hold water. And what we just need to do is to leave it as it is and proceed to clause 50. Thank you.
Honorable Chair, his fear is very important. We don't want to get into a situation where we give such powers to executive. Anything that is not in their favor, they want to stop that. This is an angle from which they are going, and I think that should be very much important, that we look at that angle too. If we give them so much power, that anything that is coming from that medium and it's not in their favor, they want to stop that. It cannot work that way. That's what he is trying to say. The world is so much developed than that.
Honorable, let's confine ourselves to what it is. The president already is mandated to take charge of the country. 1. 2, here it's not about what he likes. It's not what is stated in law. He said, if the president on reasonable grounds
considers
that it is necessary in the interest of public order, morals or security, that the importation of publications published there, in those interests, he's not saying the president's interest. So, and there are people are entrusted with those responsibilities for the security of everybody. For you, Councillor.
Yes, my submission in this, so far this bullet point 2 is concerned. If we could even put something, if the president fails, he should also be punished on this. I think it will be more progressive, and we could do. Listen. Can we listen, please? Because this is very important, and it will bring sanity in our process in terms of information is concerned. Where the president fails, we could even put a law that will also make sure he or she is forced to implement this. This is progressive. I like it.
So that a sitting president may not be tried, but you have power to do those things, Parliament. That's why you are giving that oversight. Where the president has lapses in some other things that you think he should do, you ask him to do or whatever. That's already in existence. Yes, honorable member.
What I'm trying to say is not as if the law here could be abused. Already there are guidelines, there are little rules and principles that if he or she feels reasonably, as you said, based on the ground of public order, based on the ground of health, based on the ground of moral and security, then he can publish on the Gazette for such imposition not to come. People can bring pornographic publication here and there. That is not in the interest. That is not in the interest of the states, morally, ethically. So therefore, I want them to see it from that trajectory. It's not an open check or blanket. It's been guided.
To honorable members, let me remind you, honorable members, this is the first of two bills, and we have 345 clauses. We are on clause 49, and we are to finish these two today before we close.
Speaker. Who said so? We are in the Ramadan. We are closing at 6.
No, we will cut fast here. We have provided you food.
Honorable Speaker, let me remind.
I think you are the chairman. You have approved your other paper. You finished your other paper. The office of the clerk is providing you with sumptuous iftar when you cut. So we have order. You know, this week this session is very tight. We have no space for any order. If you leave it today, it means it interrupts. We are going to have tomorrow's own. So this will go to next session again. Huh? And this bill, I think this bill, you just amended it from 2020 to 2024. I agree. That's why I said we stay to finish. It's technical, so let's stay to finish. Anyway, that is your choice. If you want us at the end of the day, if you want us to close, we close.
Yes,
but then
we close.
remember that the bill will go to next year. Okay. Yes.
I almost agreed with the provision. So now I will draw my point. I agreed with what is entailed in the bill.
Thank you very much. Honorable members, now let's go one by one with them. We now, let me prove a proposal. It is proposed that clause 48 first stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 49.
Clause 49.
Let's move.
My friend, I put it anytime you. Anyway, clause 49.
Yeah, now
clause 49.
Power to prohibit publication.
Power to prohibit publications. It is proposed that clause 49, power to prohibit publication, stand part of the bill. Those in favor, please say aye.
Chair,
not in favor, please say no.
Chair, don't forget our proposal, even if you are going to accept some. But we are saying the term seditious words should be interpreted. You understand? It needs to be interpreted. Sedition needs to be interpreted. What do you mean by sedition? Because the meanings they are giving to sedition is seditious words. What is that? So we are put into consideration the recommendations we have made. Let them interpret what is sedition, what is seditious words. Yes, he's thanking me because he's agreeing.
Very common. Remove.
Yes, Honorable Member for Woolly, you said something. You are saying?
Our recommendation is not just, we have made 2 recommendations before the final one. We are saying the term seditious words should be properly interpreted. And because that is in...
You mentioned it, and when I put the question, nobody objected, so it means people are not accepting it.
No, that is, I raised the 3.
Yeah,
I raised the 3, but the debate was centered only on the 3rd one.
No, yes, you raised the
So that
issue.
means that if they don't raise any issue, that means that they have accepted.
No, what I'm saying is, if after all what has been said,
yes,
I put the question, because I remember you talked about us interpreting seditious words. I remember it myself. Now. But if that is so, and if people believe that it should be done, they would have not agreed to the question.
No,
You only remember it now.
You only remember it now. I'm saying.
You only remember it now. Maybe they forgot.
If
You only remember it now.
If they are going to have
Chairman, can I come
need to interpret those things. Put those things, recommendations to people, whether they want seditious words to be interpreted or not.
They said no, fine.
Then if we clear all that, then you can put the question.
And it's a common law.
You know why we
Chairman.
Yeah, let me give you some few facts. They're saying, our legal luminaries are saying that this normal word, which is interpreted by the Supreme Court several times, the same language, so the interpretation is clear to everybody. Because the Supreme Court itself has interpreted it. Pardon? Can you use your mic?
Say, for example, if you say seditious publication, what is that? It means having a seditious intention.
Now, seditious is what is public. The seditious is what should be interpreted, and that has been interpreted several times by the Supreme Court.
No, let's have the interpretation here. That's what I'm saying. People who are reading the bill should know what sedition means, what seditious words mean, so that when they know what they are committing.
Honorable, you have a proposal to make, and the rest have a decision to make. Yes, so after hearing your proposal, well presented, that's where you can end.
Maintain it as it is, they will say yes. Then after that, then you will put the question for the whole, the section.
I told you, I don't usually like to go for voting straight. And what I was thinking is that so far the seditious is interpreted by the Supreme Court several times, according to them. No, we can always get that, because whatever you are doing now, you are going to the courts, and the courts will rely on those things to do it. And we can always get it. So if you want us to go and, anyway, honorable members, honorable Attorney General, what will be, they are asking us to define, interpret seditious words. And seditious, and yeah, seditious, in fact, seditious, I mean, let's just say seditious. Because if you know seditious, you know what seditious word means, and seditious publication. They want that interpreted. AG, yes, seditious. No, they just said seditious. So that they want to know what is with somebody, some people are telling me that has been interpreted by the Supreme Court several times. I don't know.
Yes, it says publication. Publication has been sedition.
I don't know, that's why I said let it be interpreted. What is sedition?
No, seditious only. The intention will be there. What they are saying is sedition. What is sedition? Honorable Member for Woolly, here by the old act, seditious intention. One, a seditious intention is an intention A, to bring into hatred or contempt, or to excite dissatisfaction against the person of the president or the government of the Gambia as by law established. B, to excite the inhabitants of the Gambia to attempt to procure the alteration otherwise than by lawful means of any matter in the Gambia as by law established. C, to bring into hatred or contempt or to excite disaffection against the administration of justice in the Gambia. D, to raise discontent or disaffection amongst the inhabitants of the Gambia. Or E, to promote feelings of ill will and hostility between different classes of population of the Gambia. No, roll this. Roll this. No, roll this up for me. Roll it one up for me. Oh, let it go up.
Oh. Oh, okay.
And it continues. But an act, speech, or publication is not seditious only by reason that it intends, one, to show that the president has been misled or mistaken in any of his or her measures. Do you understand that? But an act, speech, or publication is not seditious only by reason that it intends, A, one, to show that the president has been misled or mistaken in any of his or her measures. Two, to point out errors or defects in the government or constitution of the Gambia as by law established, or in legislation or in the administration of justice with a view to the remedying of the errors of defects. Three, to persuade the inhabitants of the Gambia to attempt to procure by lawful means the alteration of any matter in the Gambia as by law established. And four, to point out with a view to their removal any matters which are producing or have a tendency to produce feelings of ill will and enmity between different classes of the population of the Gambia. In determining whether the intention with which an act was done, words were spoken, or a document was published, was or was not seditious, every person shall be deemed to intend the consequences which will naturally follow from his or her conduct at the time and under the circumstances in which he or she so conducted himself or herself.
No, this is the exception.
But what we are saying is, you want an interpretation.
Yes, I'm saying every writing you see in the newspapers in this country, in the net, everywhere, these are the things that you are going to see there.
This is what I'm saying.
You can interpret it anyhow you want to interpret it.
No, but I've given you exceptions to those things. You've had it. So what we are saying is, you want sedition to be interpreted. If you want it interpreted, this is the meaning. That's the interpretation. This is why I said it is in the law books. It's been interpreted and interpreted.
I think the chairman of the human rights is not doing justice. You asked for it to be interpreted. We interpreted. You said no, it's colonial. You said it's colonial.
I'm saying this is the act. This is the Criminal Offences Act. This is bigger than all the other ones we are saying. I said, let's put it here. What is sedition? Let's put it here. Are you opposed to that? So what is the problem now? Let's put it here. Let's interpret it here. What is sedition? It's as simple as that.
Honorable, the one I was reading to you is the one in force now. Is the one in force now. That's the one I'm reading to you.
Okay. Now we're going to adopt it. Let them give us that instruction.
All right, Honorable Attorney General. Yes? Somebody is. Yes, Kiam?
I think Sweb's fears are being addressed from what you have just read. It has just spelled out what is said to have been seductive and what is not. The exceptions are there. So, and those can always be put out there. And I think, Sweb, I don't know if you have listened to that. They have defined and tells you and also told you what is, seductive and what is not.
Understanding. What I'm saying is that what he is reading is the old act. And now this is going to be the new
old act.
So if we have it in the old act.
So it's not the old act.
No, what we are saying it's progressive.
No, it's not the old act.
About that.
It's the current act. It's the current act. You are yet to amend. Yeah, but it's the current one. Don't say old one. Then say
what
this,
is in the
no,
current?
what you mean actually is this is the current act. You cannot call it old when we are using it. Yes.
Yeah.
Include it there. You want us to include the interpretation there. Okay. Honorable, I don't think that's difficult. All what we can do is, it's a proposed amendment. Honorable AG, are you comfortable? We just
Honorable Chair.
Please.
Sorry,
Hold on.
Let me make my point.
No, I'm talking. Honorable, how do you feel about the proposal to pick it up from the current one and then put it into this one? Is it necessary? Huh?
Yeah.
It's necessary. Yes. So somebody was talking. Who was it? Okay.
Honorable Chair, it's myself. What I'm trying to say here is, I think it is already there. In the old act, seditious have been defined and interpreted.
Honorable, what is the old act?
No, Honorable Chair, I just want to make my point. Honorable Swabel here is always saying this is colonial. But you look at what he's doing right now, it's regressive. We shouldn't put it there because he wants it to be there. No other person in this house is convinced that it has to be there except Swipe. So let's convince Honorable Swipe that the right thing.
Honorable Chair, point of
Honorable Swipe,
point of order.
Woolley East.
Point of order.
Honorable Woolley East. It should be Honorable Woolley East. Yes.
I withdraw my email submission. Honorable Woolley is. Honorable Chair, I'm convinced that, based on what you have read, the word seditious have been duly interpreted, and in this current act, you would see that seditious publication have been duly interpreted and seditious words have been interpreted. So you can easily make referrals. Unless and until if you want to satisfy Honorable Swaibu, we can add the Honorable Wille is, we can add the interpretation.
Yes, after listening thoroughly, what Swaibu said, what he said,
what the honorable member for Woolly
what
is.
honorable member for Woolly is said, because in one of the options that you read, if you looked at it very well, where it's talking about even political parties. So he was very keen about it. I think what he's saying, if members really listen to that interpretation, the interpretation we want in this should be in this.
So, honorable members, as I said, I think it's easy for us, if we want to agree, the current act is where we quoted it from, the one we are using. And the honorable minister had no problem. We can look at it at, which section is it? We are at where?
48.
48.
Yes. It's here. Interpretation of sedition.
Yeah, we can include that interpretation on the 48, and then it will end up the interpretation. Honorable members, are we fine with that? All right, honorable, but it means you have to listen also to people. Honorable member, no, you are not a very good listener. Sometimes you are the best, but sometimes you are the worst also. Yes, because you know that we have already passed clause 48. It means we have to go back on it. Huh? And if for us to go back, as you rightly reminded us last time, it means we have to rescind the first one. And then you have to move that motion. Yeah, just hold it. Yes, for honorable member for Woolly East. Move that we rescind the initial decision on clause 48.
I'm saying I move that we rescind the initial decision on 48 and include the interpretation on sedition and seditious words.
Any seconder? It's been moved and seconded. Do we all agree? Yes. Then now I put the question as amended. Honorable members, we are now including the interpretation that I read to you in the act. Huh? It is now proposed that clause 48, interpretation of section 49 to 52, stand part of the bill as amended. Those in favor, please say aye. Aye. Not in favor, please say no. The ayes have it. You can now go. 48.
Clause 50, punishment.
49. 49.
Clause 49. Power to prohibit publications.
It is proposed that clause 49, power to prohibit publication, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 50, punishments relating to prohibited publications.
It is proposed that clause 50, punishments relating to prohibited publication, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 51, delivery of prohibited publication to police station or administrative officer.
It is proposed that clause 51, Delivery of prohibited publication to police station or administrative officers stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 52, power to examine packages.
It is proposed that clause 52, power to examine packages, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 53, unlawful oaths to commit capital offenses.
It is proposed that clause 53, yes, Honorable Member for Woolly.
Our proposal here is, the recommendation is the committee that clause 53 stands part of the bill with the following consideration. 1, the penalty for this offense is unreasonable. Therefore, the committee suggests that this offense be merged with the offense of incitement under section 45 of the bill, inciting to sedition or to disobedience of unlawful order. So he's saying the penalty here should commensurate with the one that is in 45, because they think that the crimes are almost similar. That's the suggestion here. So we can look at that.
Woodley, you saying that the punishment, it should be like what? So, section 45.
Idea should commensurate with this other one. That's what our suggestion is. The punishment under section 45 should have this one should have the same punishment.
And that is unlawful inciting to sedition.
Yes, or to disobedience to unlawful order.
And this one is?
So I don't know if...
This one is unlawful oath to commit capital offenses.
Yes.
Do you know what that means?
This one.
Can you explain to us what that means? We equate it with that one.
Unlawful oath.
Because it means you have agreed to go and commit murder or something. That cannot be equal to that one. And that one, this one is you take oath to do it.
The offense you have taken oath to do has a life sentence as well.
Huh?
The offense you have taken oath
to
make attracts a life sentence as well.
What? You know, Honorable, what we are saying is this one is completely different. This is capital offense. And capital offense mostly is death or life sentence. People who have taken an oath, not only agreed, but taken an oath to go and commit capital offense. Now, no, we are not talking about, no, Honorable Member for Woolly, we agree with you. I personally agree with you that it's your role to bring out all what has been agreed, and that you are doing. And that, in fact, beyond that, we have even debated some of them,
and agreed. But this is the stage where it can be more effective. We can have new insights. If we have new insights, even if we had agreed, just like we have agreed here, we have rescinded it and taken a good one. The same thing, we are just trying to add value to what has been done. So, but remember that this one is capital punishment, capital crime, and it is consolidated by an oath to commit it. So I think the punishment is imprisonment for life. Huh? Yes. You agreed and you swore to go and commit capital punishment. So it is proposed that clause 53, unlawful oaths to commit capital offenses, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 54, other unlawful oaths to commit offenses.
It is proposed that clause 54, other unlawful oaths to commit offenses, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it. Honorable members, you see in that 54, the punishment is 7 years, am I right? You know, what I don't like much about this bill is you talk specific. This crime, 7 years. No way. All crimes are treated equal. and it treated equal because the level of punishment here, whatever level it is for this offense of other unlawful oaths to commit offenses, whatever range it may be, if you are found guilty, you are going to be sentenced to 7 years. No up and down. Yeah, no, that's not what the law is saying. Honorable, read your this thing. It says, commits a felony and is liable on conviction to imprisonment for 7 years. You are not listening to people when people listen to you. We know that that's felony and that's what it is. We are saying that felony also you have various ranges. Yeah, but it differs. Even stealing is differs. Stealing, people steal $1 is law, but it's stealing. You steal 1 million is stealing. You go and steal 1 billion is stealing. It's all penny. But the judge also will put those things into consideration. So that's what we are saying. You are tying up the judge to be able to maneuver by limiting the person based on the severity of the crime. Are you seeing eye to eye with us? Yeah, okay. Now you can forget. Yes. Yeah, go ahead.
What I'm saying, that depends on the definition of felony. You understand? Now let me come, I will learn where you are. Now what you suggest is, there can be different magnitude to your explanation. This is what I'm understanding. Now let us have a range. You know, not more than, not exceeding 7. Yes, so now the judge will be at liberty.
All right.
Within 5,
all right.
6.
Honorable members, if you look at it reads, a person who administers or is present at and consents to the administering of any oath or engagement in the nature of an oath, purporting to bind the person who takes it to act in any of the following ways. That is to say, A, to engage in a mutinous or seditious enterprise, to commit an offense not punishable with life imprisonment, to disturb the public peace. You can see the various these things there. To disturb the public peace, to be of any association, society, or confederacy formed for the purpose of doing any such act as aforesaid, to obey the order or commands of a committee or body of persons not lawfully constituted, or of a leader or commander or other person not having authority by law for that purpose, not to inform, 5. No, 6. Not to inform or give evidence against an associate confederate, or other person. And 7, not to reveal or discover an unlawful association, society, or confederacy, or an illegal act done or to be done, or an illegal oath or engagement that may have been administered or tendered to be taken by himself or herself or any other person, or the import of the oath of engagement, or B, takes an oath of engagement or engagement, not being compelled to do so, commits a felony. With all these things, one crime, all different categories. He says, if you are found guilty, 7 years. It should range. Yes.
Thank you very much. It means all those categories, they all have equal penalty. You know, you have read forms, different forms. To you, they are different, and which you read it, you know that they are different. But to the designers, it means the penalty is equal. Any form, any one of those that you have committed is 7 years. No, I understand where you come from.
Where I disagree with you is the designers of the law are not the makers of the law. It is we who make the law. If it is wrong, we will not blame them. We blame ourselves. Yeah, they say that. So not the designers. Yes.
I think, you know, he didn't follow the gist very well. The gist.
Don't blame.
Okay.
Don't blame. Please make your point. Don't blame.
No, you may be right because he doesn't have any document. So you don't have any of the documents. No report, no. It's your report.
Chair, he's a Barimunka man, he's not following the gist. So I think now, let's say not less than 3 years and not more than 7 years. At least that will be a compromise to the earlier provision to say that not less than 2, but no more than 5. At least to give flexibility for the judge, because it varies. The various offenses varies in the felony, offenses.
Yeah.
So 3 to 7.
3, 4. But we will hear the legal people. Because ordinarily we are laymen. Top of issues. You're right. Huh? Honorable, your suggestion was not less than 3, not more than 7.
And not exceeding
But
7.
I asked your opinions on those things.
It's a felony, and a felony cannot be less than 3 years. Must be 3 and above.
So not less than 3, not more than 7.
Yes.
It's okay.
I'll leave that to you, but it,
No, I mean, it's legally, it's okay.
yes.
Yes.
Yes, yes.
Yes. Okay. Yes.
Actually, if you say all these offenses, no matter what, the degree of each of them in one way or the other will differ in court, and then the judge should have option. So if you pick it at 7 years, that means there will be no option. It is only going to be 7 years, nothing less, nothing more. So no matter how the severity, less severity of the offense is, that's why we say if 3 years is within the law as far as felony is concerned, then let that be the minimum and maximum be 7 years.
No, I disagree.
No, yeah, but he doesn't have the documents, so he will not be able to follow. So, honorable members, on this particular issue that I read to you, the proposal is, instead of specific 7 years, we're now saying that to imprisonment for not less than 3 years and not more than 7 years. Yes? Lower Fuladu. I want to remind you, if I can move a motion, we close at 5. Today is first day of Ramadan, please. Yes. It's 6. Yeah, my motion is that we close at 5. No, there is, you see, that's my motion. It's, yeah, you know, it can be removed, I cannot, but yes, what I'm... Honorable members, we have this thing before we pass on. This amendment, are you okay with it? Except for central body. No, you have got enough. Honorable members, the proposal is not less than 3 years, not more than 7 years. It's okay? Okay, yes?
I know there is majority are saying yes, but honorable, felony is a serious crime by law. It's a serious crime. And we are putting the law so that we deter others not to be involved in such. So if you
when he was saying it, if you have felony, it means you cannot go below 3 years. And we are saying 3 years and a maximum of 7 years. What is bada?
Now it means if you make it open, then you know these like we are not looking at the severity of those ones that you have mentioned, but we are looking at it in tandem that this is a crime being committed as felony. So let's leave it to 7 years. Why are you giving the
why?
judge?
I will give you a reason. There are felony crimes that are for 3 years. There are felony crimes for 4 years. Why should this one be 7 years specific? Why? That's why, because it's a group, that's why, in fact, you should give it space. They don't all, yes. The now is A, B, C, D. Give it room for the magistrate or judge to sit down, depending on the facts presented to him. He will gauge it and break it down and give you the appropriate one. So, honorable member, it is proposed that clause, where is it? 54. Order unlawful oaths to commit offenses stand part of the bill as amended. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 55, defense of compulsion.
It is proposed that clause 55, defense of compulsion, stand part of the bill. Those in favor, please say aye. Not in favor, please say no.
The ayes have it.
Clause 56, unlawful drilling.
Who is making observation? Honorable member for Woodley, before you come in.
Okay.
Just before you come in. Honorable members, is 16:53. It's almost 5. We have not prayed. Tomorrow we will not do it as we do. We will have to go for prayers. We will go for prayers and come. But what I'm saying is, are we staying to finish this thing honestly, or we are going to court? Because we have, I think the office of the clerk told me that they are preparing.
Chair, I'm also reliably informed that they've arranged iftar service in-house. So there is iftar provided here in the parliament.
No, last session on Thursday, members almost scolded me and said, what about our dinner? I said, we never expected that we will be here until that time. They said, no. So now if we prepare, because we are expected to do this and be here, we prepare, you are now saying, Madam's list.
That will take care of the lunch. You are just exchanging with the lunch. You don't have any lunch today.
Oh, honorable member, you are also in for us to break away.
Chair, we want to be here.
For me, Honorable, 2 things. I know that this bill has been with us for almost 4 or 5 years. This bill. This particular bill we are dealing with. No, they are not twins. They are not. We are dealing with one. After, you see, that's why they are not twins. The twins, they go together. You know, they don't, these things. So, honorable members, because of that, 2, and we are in Ramadan, we have a hectic schedule. To be closing at 6 o'clock when we don't start on time, it will be difficult. Otherwise, we will have a lot of unfinished business.
Chair, we are in line with you.
So I was going to suggest that today being the first day, we'll make justice to this bill and make sure we complete the 2 bills tonight. No, if you had gone part by part, the work that has been done would not have been done. All right. But what will happen is, when we finish, when we close, anytime we close, the bill will be lying somewhere until another session. You know that, because we have already got scheduled businesses in our presence. No, but why would you alter it? Yes, please. Is it Kiang?
Yes.
Kiang West?
Honorable Chair, if we still overstretch, we may not be able to get the desired result that is keeping us here till that time that you are trying us to keep here. If we are overstretched, we cannot be able to debate on this, and we cannot do justice to the document. So I think we even if we sit beyond 6, we cannot finish this document. We cannot finish this until next morning.
Kiang West. Honorable, you have been here sometimes until very late at night. When we are, the only thing holding us is to listen to you people to talk.
Dom Sukaroti.
But we will give you food.
Honorable Chair. Honorable Chair. Honorable Chair.
You cannot call this thing as a food.
Honorable Chair.
Is yours. The decision is yours. when it is 5:30, somebody either moves the motion for us to continue to finish. If there is no motion, I will adjourn at 6. Eh? Pardon?
I will raise the motion for us to work to complete the business.
Let's Chair, before you come, we'll still appeal to them. Hence, Clerk has promised that he's organized a special iftar for members of Parliament, and also looking at we've gone very far now, almost halfway. So almost halfway. Almost halfway. Let's stay and finish this bill. So let's stay and finish this one.
Honorable members, honorable, you see, we are wasting more time. What if we either agree, because left to me alone, even if we are going to leave the other one until next session, but this one we try to complete. That's what pardon? I'm not hearing you. No, somebody is speaking there.
I said yes. I am in agreement with you, Honorable Chair.
Yes, Honorable.
Yeah.
Is it become a south?
No, it's BANJUL not.
Oh, BANJUL not.
Yes. I said I am in agreement with you.
Okay.
Let us finish this document for today.
All right. So, honorable members, I think we have very good.
Let's stay and work.
Now, yes. No debate. This one touches on the life of everybody. This one is a lifeline. It is proposed. Where are you? 56? Read it. You have read it. Honorable members, it is proposed that clause 56, unlawful drilling, stand part of the. Yes, you had your listings, exactly.
Come up. Yes, 56. Honorable Speaker, 56(1)(a), 56(1)(a), the first line where it is mentioned the minister.
Yes.
So we are proposing that we specify that to mean Minister of Defense. Let it be specified, Minister of Defense. Because we are talking about training and drilling and all those things. That is our suggestion there. And then the second one.
No, before you go.
Yeah.
He said a person who, without the permission of the Minister
of Defense,
trains or drills any other person to the use of arms or the practice of military exercises, movements or evolutions.
That particular minister should be the Minister of Defense. So can we specify that? That's the suggestion. Because even though it's the Minister of Justice that is responsible of the bill, will be the one responsible of the act. But in this particular area, we think it's the Minister of Defense. That should be.
Why do you think it's the Minister of Defense?
Defense and all these matters that are mentioned here. Drilling and training, etc., etc.
Honorable Minister.
You don't want to give administration of a legislation to more than one minister. Probably, I see your concern. What you can do, maybe you can say, you can create C and then say the minister, before granting such a consent, must consult with Minister of Defense. But the granting of the consent, you cannot move that to another minister. Then you'll have different ministers administering this legislation. And that can create confusion. there must be one minister to administer the legislation. But if that minister need to consult with another minister in granting a specific consent like here, you can recommend that. Yeah.
With this, this bill now. But you cannot put Minister of Defense here again, and then you are doing that. Pardon? You said you can do what?
Consult with the Minister of Defense.
Say it. We want it correct. Say the proposed amendment.
Can the minister repeat exactly what he said?
You know, we have A and B. All right? We can create C to say the minister, in granting the consent referred to in paragraph A above, shall consult with the Minister of Defense. The minister, in granting the consent referred to in paragraph A above, or permission, because the word there is permission, not consent, shall consult with the Minister of Defense. You know, the offense is if you do it without the permission of the minister. Now, C is saying if the minister is to grant such permission, he should do so in consultation with the Minister of Defense.
Yes, you said the minister?
The minister, in granting permission referred to in paragraph A above,
granting
permission referred to in paragraph A above,
permission referred
to paragraph A above, permission,
Referred
granting
to-
permission referred to in paragraph A above,
in
shall consult with the Minister of Defense.
paragraph A above shall consult with the Minister of Defense. Hey, honorable members.
Or better still, my apologies. Let's highlight those of you who are typing. Lift that. We are trying to say it might not be the place to insert it. What is said is okay, but we can insert it as a new sub 2, and then this current 2B3, because we have to create the offense and punish it first. Then we talk about the consent.
Then we can just say that it's sub 2.
Yeah, it's sub 2. So it's now
Sub
going
2,
to be sub,
and then sub 2 here would be 3.
with 3, yes. That's fine. Yes.
Honorable members, minority, majority. I need to go and pray. I don't know, we either adjourn or let me ask one of you to come and sit in place. Huh? You can come and make the suggestion. You are part of it this time.
Suggestion.
Yes. Come and take the seat.
Honorable Speaker, if I may, I'm not sure the proceeding is sensitive to Honorable Minister's situation. Members have the opportunity to go in and out, but Honorable Minister and yourself, we have not got the opportunity this morning to step up. So if you are stepping up, I think it's fair that I'm also allowed to step up.
It's covered. Some of you not fasting have gone to eat. Some of you have gone to pray. And pardon? I'm not.
Maybe Fullers. I don't think anybody is not fasting. Maybe
And
Fullers.
I know of Jolas who are not fasting. So, yes. So, honorable members, I think we. No, but I have to go. We will say I have to go up. Honorable members, we will suspend the committee of the whole house and resume the assembly. In the next, honorable members, we are to be back at 17.
Speaker, we say division. We're calling for division.
17:30. At 17:30, we'll be back.
Speaker, we're calling for division.